I do have to wait on them before we can really start work, but I have a few things that I need to review with the audience prior to. So I'll start with that so that we won't be here all night for some of you. All right. At this time, I'd like to call to order the May 4th, 2026 meeting of the Charleston County Board of Zoning Appeals, also known as the BZA. The board members that will hear your case tonight are as follows: Mr. Truslow, Mr. Neal to my right, and then we have Mr. Nelson, Ms. Smith, and Mr. Jordan. Mr. Jordan should be on the way, and Mr. Neal should be on the way as well. Staff members present that will hear your case tonight is Ms. Brooks, Mr. Carlisle, Ms. Clark, Ms. Gamble, Mr. Hare, Ms. Hayes, Ms. White, Ms. Bache, and Ms. Working. And Mr. Kevin Hughie is our attorney, and he is on his way as well. Because the hearing tonight is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was printed in the Post and Courier. A sign was posted on or near the designated property, and a notice was mailed to the applicants or the applicants' representatives, to the property owners within 300 feet of the property, and to property and people and persons of interest. Persons, organizations, and new media have also requested declaration of our meeting and have also been notified. Board members, the meeting notes for April 6, 2026 public hearing were sent to you. Are there any? Yeah, wait on that. We need to wait on that. So I'm sorry, I'm going to skip to that part.
With Mr. Jordan here, can we go ahead and motion and vote on it? That gives us 5.
That gives us 5, yeah.
Okay.
Thank you. Board members, meeting notes of April 6th.
I did that. She's not coming tonight?
Ms. Smith would not be here tonight.
I guess that's what happened.
Give us a moment. We're going to get it together. I'll say it again. Board members, the meeting notes from April 6, 2026 of the public hearing were sent to you. Are there any changes? If not, can I have a motion to approve and a second?
Motion to approve.
Second.
Thank you. So we have a motion that has been properly moved and second. All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. Thank you. The Board of Zoning Appeals is a quasi-judicial body that has decision-making authority on the following: zoning-related administrative decisions. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that an error in the order, the requirement, decision, or determination made by the administrative official in the administration or the enforcement of a zoning-related regulations. A 2/3 quorum present is required to overturn the decision of the planning director in an appeal. We also have special exceptions. A special exception is issued by the BZA authorizing a particular use in a specific location within the zoning district, demonstrating that such a use complies with all the conditions and standards specified in the Zoning and Land Development Regulation Ordinance, also known as ZELDAR. The BZA must find that the special exception meets all 6 of the approval criteria in the ordinance in order to grant a special exception, and a simple majority is required to approve. And then finally, we have a variance. A variance is a relaxation of the BZA's regulations of the ordinance where such an act will not be contrary to the public interest and where it is owing to the conditions particular to the property and is not the result of the own actions or the situation of the applicant. A literal enforcement of the code will result in the undue hardship. And such a variance is consistent with Section 6-29-800 of the Code of the Law of South Carolina, along with Title 6, Chapter 29. The BZA must find that the variance request meets all 7 of the approval criteria in the ordinance in order to grant a variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering information and evidence that is pertinent to each case. If a member of the BZA feels a need for further information to clarify a case, the board member has the authority to subpoena witnesses. It is understood that the are binding, and we can take no actions that would neglect their jurisdiction over your property. In addition to your testimony, the board has been presented written information submitted by the staff, by the applicant, or the applicant's agent for each case. This information is considered to be evidence and is entered into the body for this record. It is assumed that it is complete, true, and accurate. In addition, we have been presented data assembled by staff for the purpose of clarifying the location of the application and its effect on surrounding properties. Our board has been empowered to approve with conditions, or deny special exception variances requests. We're also authorized to defer a case should there be a need to obtain additional information. The BZA final decision will be mailed within 10 working days of this public hearing. It will be mailed via certified mail to the applicant and U.S. mail to neighbors and the community interest on our notice. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exception granted in this evening are valid for 12 months after this meeting, and a 1-year extension may be granted only if construction or development has been commenced or has been diligently pursued. However, if an applicant's request is disapproved, the applicant wishes to appeal the decision of this board concerning the case, an appeal must be addressed by circuit court. South Carolina Code 6-28-820 states that an appeal must be filed by the applicant within 30 days of the decision of this board when it's been mailed to them. Failure to file an appeal within that time limit deprives this court of the jurisdiction to hear a matter. Because this is a quasi-judicial body, everything that was said in this meeting is true, complete, and accurate. All the information provided to the BZA is considered evidence, and the board may certify contempt of circuit court if false statements are made either in writing or orally. Each person who wishes to speak to this board tonight will be sworn in by the BZA secretary before providing testimony or evidence. In order to expedite this procedure, our secretary, Ms. Working, will administer the oath. And at this time, if you would stand as a group, she will administer the oath.
Please raise your right hand. I will say the oath, and you will say I do. I swear to tell the truth and nothing but the truth.
I do.
Thank you.
Thank you, Ms. Working. I will call each case by case number. Staff will present facts that are pertinent to the case, limited to 5 minutes. I will then call the applicant. The applicant will stand and state his or her name and current address for the record before presenting testimony pertinent to the case, limited to 5 minutes. I will then ask for those speaking in support or in opposition, and they will follow the same procedure for identifying themselves, and they are limited to 2 minutes each. The applicant will then have a chance to reply to the opposition, limited to 2 minutes. And then the BZA will make a motion to close the case to the public. And finally, the BZA will make a motion concerning the application, stating specific facts and conclusions of law. Tonight, we will hear 10 new business cases. Ms. Working, our first case tonight is BZA 03-26-00958.
Oh, hold on. Sorry. I'm on the right one.
Excuse me, 957. I apologize. 957. I want to get ahead of everybody, I guess. Please forgive me. And ladies and gentlemen, you notice that we have monitors down here. Very seldom will you see us looking at the monitors behind us, okay? And always please be conscious of the time, because the time will be moving after you get up to the podium. Thank you, Ms. Working.
Okay. Our first case tonight is an appeal, and Mr. Ray just went over the order for variances and special exceptions. They're slightly different for appeals. I'm just going to present
Please.
the where the property is located, the basic information of the appeal, but the appellant will present their case first, and they'll be limited to 10 minutes. And then the board can question the appellant, and then the official being appealed will present for 10 minutes, or up to 10 minutes, and then answer any questions. Presentations or information either in support or in opposition are limited to 2 minutes per person. And then they will have an opportunity, the appellant will have an opportunity to reply to any opposition before y'all close the case to the public and vote on the appeal. So again, this is BCA 0326000957. The appellant is Lauren McGill Milton, and she's representing the Friends of Coastal South Carolina and South Carolina Coastal Conservation League. The property is located at 1345 Lofton Road in 8880 Highway 17 Northeast area. The tax map number is 731-00-00014 and 731-00-00101. And the properties are located in the Agricultural Preservation Zoning District. The decision being appealed is, in quote, the February 19, 2026 administrative determination of the interim zoning and planning director rejecting the appellant's previously filed appeal as untimely and refusing to transmit the appeal to the Board of Zoning Appeals. This is a location map of the properties, and the zoning map for the two properties. Again, it's in the AG10 zoning. This is the ordinance section regarding appeals, and then the ordinance section regarding resource extraction. The 300-foot radius map, aerials. We posted this property on April 15th, 2026. Okay, and that concludes my introduction.
Okay. Thank you, Ms. Working. Is the applicant present? Very good. If you would, please state your name and address for the record and tell us.
Absolutely. My name is Lauren McGill Milton, and my work address for South Carolina Environmental Law Project is 510 Live Oak, Mount Pleasant. I believe that's 29464.
All right. And the last name again, please?
It is Milton, Milton.
Thank you, Ms. Milton. Proceed.
So first of all, members of the board, I just want to say thank you so much for the opportunity to speak today. Again, my name is Lauren McGill Milton, and I am here on behalf of Friends of Coastal South Carolina and the South Carolina Coastal Conservation League. My clients are nonprofit conservation organizations. They have members who live and work and travel and recreate and care deeply about the McClellanville community and the natural resources there that are affected by land use decisions in this part of Charleston County. They participated in the earlier proceedings, and this proposed mining use affects more than just the applicant's parcel. So it affects neighboring residents, traffic and safety on rural roads and wetlands and drainage systems, but also the integrity of this county's zoning process. One of the things that I really wanted to start with is the history. I just kind of spoke to it a moment ago when talking about 2023, but the chronology is actually the point. This didn't begin as a routine 2-acre grading request. In 2023, this same mining use came before this very board through the special exception process. And county staff treated resource extraction as requiring special exception. It went through it, and the board correctly denied it, and that denial was never reversed. Friends of Coastal SC and the South Carolina Coastal Conservation League were involved in that 2023 case. And I don't mean just being here arguing to you guys. I mean, we had an entire court case where the BZA was sued, and my clients stepped in as interveners in front of an action in front of Judge Scarborough who allowed us to intervene in that process. And the reason we intervened at that time was simple, because the board had already recognized that this was not an appropriate place for mining, and appellants wanted that decision to remain in place unless it was reversed through the proper legal process. But that never happened, and the applicant didn't obtain a judicial reversal. The Circuit Court appeal was dismissed without prejudice in March of 2025, March 19th, 2025. So the applicant didn't win the right to mine through the BZA process. It changed routes. And that's why this appeal matters, because after the 2023 denial, that's when the applicant came back with a different framing, a 2-acre resource extraction proposal under ZLDR 6.4.14. You know, as an initial point, staff shouldn't be able to convert a denied mining use into an administratively exempt mining operation unless the ordinance actually allows that. And if staff decided the exemption applied, then that decision needed to be clear and identifiable and reviewable. One of the main points that we had just talked about a moment ago, and if you guys are interested in seeing it, I have some supplements here that the record kind of omits and doesn't discuss. If you guys would like these, I can set these right here if you guys hand those up. Exhibit 1 is the prior Circuit Court appeal docket and the March 19th, 2025 stipulation of dismissal without prejudice. The only reason I bring this to you is because the staff chronology references a November 7th, 2024 communication to the Circuit Court stating that through that case, we all knew then that the applicant intended to withdraw the prior appeal because a new application had been filed. You guys can look at the court record there. I never saw that filing during the time that I was involved in the case. The actual dismissal document that is in there is from March 19th, 2025, dismisses the appeal without prejudice. So that prior BZA, we had no foreshadowing that they were going to go a different process or anything else. Exhibit number 2 is interesting. This is the February 19th, 2026 email that we sent them regarding ongoing work and a posted stop work order with signage from the same day. So we have a stop work. I have contemporary evidence that I can put forth with one of the witnesses that's here today that they saw this sign starting in December, posted up through February. If the applicant met everything for this exemption, it's curious why there was a stop work order and my clients were told that they had not yet met all of the requirements for that. And the reason that I'm offering that is because it shows that the August 2029 finality theory doesn't fit the later sequence. If that had been the complete final settled authorization for resource extraction, the stop work order kind of runs against that theory. And the same day dispute that we're having over the automatic stay is kind of hard to square with that position. Exhibit number 3, and the reason I added that is because that's a December 17th letter that we wrote to Charleston County. What this and the rest of the record shows is that my clients who live and work in this area saw mining going on, and from the moment that we saw that, we issued a FOIA. We were working to find out information. We were working to get in touch with the county. And that letter raised then the same issue that's now before the board, which is whether this resource operation could be treated as exempt under 6.4.14. Because we still had the other denial, despite the absence of the residential, the recreational, or the bona fide agricultural use on the parcels. I have not seen, still, in the FOIA documents that I've gotten and in the record, a decision from staff that says that this meets residential, recreational, or bona fide agricultural use on there. I just have never seen the threshold finding that the exemption requires. And we hear that August 29th started the clock. But if that was where that determination was made, shouldn't we be able to see that in the record if I'm being held to that timeline? Where is that decision? Then we also hear January 5th is maybe a decision that was in there. But to me, that's the key point. A strict deadline should require a clear trigger. If we can't start the appeal clock from an unstated exemption decision or a silent inference from a site plan approval. And there is South Carolina law that is on point on this. Pickens County versus South Carolina DHEC, and that's a 2021 case when they basically said that you can't dismiss a challenge as untimely without first deciding whether DHEC had properly classified the permit challenge and as a modification, and what exactly is this? And that's what I'm saying, is that that record doesn't say that this is residential, recreational, or bona fide agricultural. This is the same point that I was bringing up in December when we were receiving calls from our clients and community members that work was occurring on the property. We received photographs of that stop work, and we're trying to talk to the county throughout the entire process. So this just isn't consistent with the county's position that there was a clear approval on August 29th. It's also not clear that there's one in January, considering that stop work was posted up until February. My clients did not sit on our rights here. After I received the reports from them, we sent the December 17th letter asking the county to clarify the position and say, how is this residential, recreational, or a bona fide agricultural use? We raised the prior BZA denial that you guys had done in 2023. We discussed the narrow language of 6.4.14 because that language says solely for residential, recreational, or bona fide agricultural use. And yet, when you look at the record, what you'll see is that this is about mining, and it's about segmenting what was already denied just to get mining done on a parcel where it was already denied. So we asked the county to identify the ZLDR provisions. And basically, when we submitted that first appeal on a form, it's very unclear here if a decision had been made. I had done a FOIA. I was still waiting on the FOIA results. Hadn't gotten anything, did not know that a decision had been made or if an appeal was necessary. And by the time that we had gotten that form in, we were told, or our appeal in, we were told that it needed to be on a different form. So that was submitted on January 29th, within 30 days of what may be the January 5th decision, if the August 29th one is not the triggering decision. But our first appeal, which was on January 29th, is absolutely timely if January 5th is the operative decision. And then the county let us know that they had a preferred appeal form, that this would need to proceed like a normal applicant who brings a proposal to the BZA. And so we immediately filled out that form, got it back in the next day, and that was a supplement, as we see it, to the January 29th appeal. It did not start a new appeal. There's a lot of law, again, in South Carolina that supports what we have here. There's a case called Newton versus Zoning Board of Appeals, and it says that, we should have the grounds for review. There should be something in that file that says that this is residential, recreational, or a bona fide agricultural use. We have argued throughout our pleadings that we do not see that in there and that it is not. There's another case, Ware versus Beaufort County Zoning Board of Appeals, and it's consistent with the same principle that a good faith filing followed by a procedural supplement should not be treated as a jurisdictional nullity. The county's August 29th theory fails for another reason, because the record doesn't show what was supposedly decided. And there's a very recent case as of April 15th, 2026 called Alliance to Preserve the Old White Horse Road Corridor, LLC versus RP&L, LLC. And, we need something to hinge on. If my clients are being held to the point that they should have recognized that there was a decision, I should still be able to point to a written decision that says that this is a valid exemption.
Okay. So I'm going to grant you 30 more seconds.
Okay. I will go ahead and handle the rest of this in there, but the applicant's materials describe resource extraction. This BZA has already denied that once. I would ask you to let this appeal stand so that we can get to the merits of why mining does not belong in this area, and your decision was right in 2023.
All right.
Thank you.
Hold on. Let me see if we have any board members.
I got a host, but I'll go last.
I was hoping not to start on your side anyway. Do we have any questions on this side?
I'd prefer Mr. Neal start.
Uh-oh.
I'd like to hear this.
Okay.
I don't know if that's a good thing or a bad thing.
Okay, go for it, my friend.
Okay. Well, thank you, Mr. Chair. I just want to make sure I'm okay on understand the timeline, and it sounds like there's a lot of moving parts here, and
Right.
I really want to make sure I'm understanding what you are appealing, your group is appealing, which I think I understand it from my readings and stuff. Right? So a lot of this is just going to be yes and no's or correction or a little bit of stuff in timelines. So you are appealing the decision basically that the administrator has said that your appeal was not filed timely, and that appeal is supposed to be within 30 days of what? The 30 days of the decision that allowed whatever is going on the property to happen for that permit, or are you appealing some other decision?
So just to make it clear, and I understand the confusion there. So our appeal that we filed sent on January 29th was challenging staff's decision to apply 6.4.14 without any justification for the residential bona fide agricultural use.
So you're challenging that decision. Okay, that makes sense.
And then
to me.
we got a rejection and said, no, we're not going to hear your appeal. You can't get to the BZA. We made a decision.
Right, I understand.
Good.
So you're really, even though you're upset with the decision that was made to allow whatever's going on this property, you're just worried about the decision, the initial appeal decision.
The timing,
Yeah,
because so we can get to the merits now.
That makes perfectly good. And you made mention of the 30 days, which is the current standard for appealing. The 30 days, tell us exactly how you interpret the 30 days from when. Is it 30 days from a permit being signed off on? Is it 30 days from some decision? I mean, I know it's a decision from this body normally, but this was not a BZA decision. This was a staff decision. So tell me about the timeliness of that 30 days, so that because you feel like you didn't have the right time merit. Is that correct? Yeah.
So let me go ahead and say that 30 days as a lawyer is pretty much what everything kind of runs on. It's always 30 days. Here I didn't have a clear decision. Again, I was relying on FOIA documents that I also was not getting within 30 days to try to find out when everything was. The county is the one that has said that 3.13.3 is what applies, which is appeals of administrative decisions shall be filed within 30 calendar days from the date of the administrative decision. But within that, I've been given now 2 dates that apply, August 29th and January 5th. I hold that my appeal, whether it was on the right form or not, was filed January 29th within 30 days of that. So I met that. Okay. They wanted it on the form, then I later supplemented the form, but I would still say, despite having everything stacked against me without a public decision, without an actual written decision, we still managed to get it in within 30 days.
All right, because I'm focusing all my attention on the decision, the administrative decision, not on the property and all the different things that a group may like about it or not like about it. But I will have one question about that, if I may ask.
Go ahead.
So in a very brief response, explain to me the difference, in your opinion, of the initial application that happened years ago that was defeated or denied in front of this board versus the second application, so I can understand how one is mining and one is not mining. Are the applications the same?
I would suppose that under this exemption, they'd be chewing through it a little bit slower, but it is the same mining on the same parcel in the still same area that is across from a school. It's the same thing.
Okay, that's what I need. That's what I need to know. Thank you, Mr. Chair.
Okay. You have a question, sir?
I do.
Yeah.
Thank you for your presentation. It was very well made, and I understand it. First of all, before I'm going to ask you what I think are some yes and no questions for you, but how does and I'm taking the date, the proper date is January 4th, 2026. How is the appeal that you filed markedly different on the form than the county would say that they wanted you to use?
It is no different. It contained all of the same information. There is nothing that was on the form that was not in my original appeal, and vice versa.
Okay, so I'm going to ask you just a series of questions I think call for a yes or no. How are they possibly prejudiced by you using one form versus another? It seems like it's, form over substance. I know as a lawyer, the court tells you to use a certain font. If you don't use the font, they're not going to throw out your case. They're just going to say, go back and put it on another form or use a different font. But are they prejudiced at all?
They are not. If it in my view, it contains the same information and they could read it the same way either way.
So your drop date to file an appeal, a drop date, dead on arrival, if you will, would be February 4th, 2026. Is that correct?
I believe so, yes, based on if we're believing January 5th. But yeah.
I'm going with the date of January. So your appeal was within 30 days.
Yes.
Okay. We've already talked about what prejudice they would suffer if you were allowed to just come here. You and the community, would the community be prejudiced if you aren't allowed to proceed?
Absolutely.
Okay. Because they wouldn't have any right, and the mine would go ahead and...
They have not been able to be heard about this since 2023, and they thought it was final then.
Okay. So your contention is the public ought to have a right in this case to have some input and to be heard.
Absolutely.
And I can recall, because I was on the board in 2023, I've never seen a larger group of concerned citizens that warmed my heart that the public was so involved. But, you would want them to have some say-so in what happens in their community, especially when it's changing. There's would be an exception to be made, and it would change from agricultural to mining.
Correct.
In addition, would you be concerned about I think might have been the Department of Agriculture that said they were concerned about taking materials away from an agricultural area that couldn't be rezoned? Is that one of your other conditions?
I mean,
concerns.
Our concerns for the environment of the site, of course, are always, wildlife, water quality, and everything that. But I also think it can't be separated here from the community concerns of parents who have children that go to a school that has a mine across from it.
Well, I very well remember several of the concerns were the safety of the children,
yep.
and somebody made a very good presentation at the time, safety of the children and safety of the public on a well-traveled Highway 17 with, basically it was going to be a U-turn for the trucks to turn in and to get to the property.
Correct.
So, all right, so your contention is they would be prejudiced if they don't have a right to speak to this?
And be heard about what's going on in their community. Absolutely.
Okay. Now, I'm going to ask you a question I already know the answer. I wouldn't ask the question if I didn't think I knew the answer.
Okay.
But as a lawyer, and I've been practicing law for over 40 years, I know that we have a duty to be candid with tribunals.
Absolutely.
I couldn't find any law that would support the position taken by the county. And I looked and I looked and I looked. Are you and what they're dealing with is courts aren't hyper technical in this
Correct.
context. They want sunshine and they want to be fair to everybody. Are you aware of one single case? I'm not. And are you aware of a single case in South Carolina that supports the position that's being taken by?
I am not, but I have a lot of law that is to the contrary of the position taken.
Well,
by
you've
them.
cited some of the ones that I'm
And
familiar with.
I have more. I actually have a copy of the cases, but they're printed front to back and they're stapled all together if you guys would want it. But I have a lot of law to the contrary if y'all are interested in hearing it.
So you gave an unambiguous notice of intention to appeal. Is that correct?
Correct.
Number two, it was filed in the proper place with the proper party and timely.
Yes, sir.
And number three, only the community and people concerned about the environment would be prejudiced. The respondent, the county, would not be prejudiced, and they could appeal if they didn't like what we do. Is that correct?
Correct.
All right.
And that's usually the way that these work. They're a lot more straightforward for everybody, I think, when they usually work that way.
Well, I want to make sure we're feeding everybody out of the same spoon of justice. So thank you.
I agree. Thank you very much.
Thank you.
Anything
Okay.
else?
Okay.
Thank you, Mr. Chair. Thank you, Ms. Milton. So as I was reviewing this case, there's several things that kind of stood out for me. The initial application that was made to this board was in 2023, and clearly it was denied. In your opinion, would the applicant have the right to reapply for that use?
I would say that underneath the rules, they probably could have reapplied for that use, but I would say that the more straightforward thing is if they brought an action suing this body in circuit court that we were well underway to do, the more straightforward thing would be to fight in that case for that, and it's still, it's not dismissed with prejudice. So they could still bring that back, so I would say that would be the first route, because Judge Scarborough is pretty up to date with the law and capable of finishing that.
In that particular instance, it would still be fighting the proposed plan that was put forth before this board at that time, correct?
Correct.
Now, in this case, and even in that situation, the way the BZA rules work, they could have come back here with the exact same plan a year later and gone through the same process, correct?
Correct.
Now, what if they would have amended their plan to a lesser impact? Could they have brought that before this board within a year?
They absolutely could have brought that in there, but there is evidence in the appeal that I filed that they would have preferred to do the segmentation route to avoid having to risk a denial from y'all again.
And that certainly would be a risk coming back before this board. But this particular property is zoned AG10, correct?
Correct.
What type of uses would be allowed on the AG10 property?
Not mining.
Not mining unless it meets certain exemptions,
Correct.
which is part of this, I guess, where we're heading with this. But
Correct.
it's primarily going to be agriculture or residential, correct?
Yes.
Well, with that, if they had the right to reapply, and they did, and the administrator made a decision on August 29, 2025, quite frankly, I'm struggling that they amended their plans, which is their right to do. They did so in a way that met the exemptions sorry, I don't have it memorized, but met the exemptions that we've discussed. How do I get past the decision being made on August 29, 2025, and not January the 5th, 2026?
Sorry, can you state that question again?
I am struggling. The administrative decision, from my review of the record, really appears to have occurred on August 29, 2025.
Okay.
So how do I get past that and get to your assertion that and my colleague's assertion that the decision was made on January 5th, 2026?
So the August 29th decision that's in there, if I could find it in here in the record, that documentation that's in there lets them know that there are further steps that would come ahead in any sort of decision to allow this exemption. It doesn't say, you're cool, go work now, at all. It says there are additional steps that would be coming. Furthermore, I'm not even sure about January 5th because we still don't, it is clear that even by that date, they had not met the requirements to do whatever it was that they were doing already at that site. So I think that that's another, kind of thing that's pointed there. The other thing is, again, we don't have a written decision in there that says, yes, that they are exempt solely for one of these three uses. When you look at the materials that are in there, it is focused on resource extraction. It's not talking about any agricultural use. It's not talking about any residential use. Maybe there might be one in the future, but it's not talking about we need this exemption for one of these three reasons, which I'm not going to list again because it's been...
But we do have documentation that was stamped by the County Planning Department on August the 29th, 2025, stating that the application meets the requirements of that particular section of Zeldar.
And it does not say how, and it still lets them know that additional steps are needed before they are allowed to operate underneath that exemption. We still had to stop work after that.
So again, that kind of gets us away from the point of what we're arguing here, is whether or not the decision date was August the 29th or whether it was January 5th. And this is why I struggle with it. I deal with a lot of permits myself in my career from from Department of Environmental Services to the Corps of Engineers. And oftentimes we receive permits with a lot of special conditions in them that we have to adhere to before we can start work on a project. And I liken this particular situation to something like that. And I'm struggling to come to the conclusion that the department's decision was on January the 25th, 2026. And I'm trying to get help to get there.
No, absolutely. And that's what I'm saying is that the staff in response, there is in the file, it says after August, there are further steps. We need to, I think it was the site review plan. I'm trying to flip through here and find it, but they absolutely say that there are further steps in before they're allowed to proceed.
Yeah, they had to put up
underneath
tree
this exemption.
barricades, and they had to show proof of tree barricades. There were fees that they had to pay in order for the zoning permit to be issued. But is that the administrative decision? The administrative decision seems to have been made on August the 29th.
To me, the administrative decision, one, which I still don't know that I've seen in the file, would be something saying that this meets one of those three uses, solely for one of those three uses. And that decision was when they were free to operate without that exemption. If you still have steps left in a process, just to use your example with DES, if DES says we're still going through the process and I need you to respond to these comments, or I need your bond or your filing fee, you're going to be in a world of trouble if you start mining without those things, without responding to their comments, without doing anything else. And you're going to get a stop work from DES like you would get, I don't know, from a county if you hadn't met all of the requirements.
If that permit hadn't been issued and you hadn't met those requirements. But if the permit has been issued and you're still working toward those special conditions, I disagree with your assertion there. But that's just, I'm trying to get to January the 5th, and I'm struggling with it, and I appreciate the attempts to get me there.
The January 5th also came from the county's own things. When they responded to me, they said the decision was made August 29th or January the 5th. From my position representing my clients on when a due date is due, if I'm being expected to be held to a certain date, it shouldn't be difficult to ascertain, especially what date the county is operating from.
So let me just shed a little light. The majority of our approvals are approvals with conditions.
Right.
And the conditions can spell out an array of things. And they have particular time periods in which they need to have. But the initial approval is the approval. And the conditions follow along with it. And they have to be completely done with the conditions at the conclusion of the project. So I think I don't want to get caught up in, it was approved here, but they're still doing work. We consistently make approvals with conditions. And that's just how we operate, and that's how it works here in this county with that.
Yes.
So I just want to make that abundantly clear.
Yeah. I absolutely understand that y'all might have conditions, and like I said, DES often works the same way. You'll have to have these conditions, and you have to have these, they're called BMPs or best management practices that you're abiding by while you're working on that site. But if you don't do that, then the other thing that happens is that your permit can be
Gets pulled.
rescinded, right?
That's
It
correct.
can be, but it hasn't been at this point. Not that I know of. We can ask staff to
Hasn't been,
verify
to my
that.
knowledge.
But yes, thank you for
Did you? Okay.
letting me have that line of questions.
Okay, thank you. Do we have any other questions on Ms. Smith?
Can you describe again what those kind of special exceptions would be for to allow something like mining on a site?
So you mean under 6.4.14 under the exemption, or do you mean the normal special exception that y'all denied this on in 2023?
You mentioned an exception for agricultural.
Yes, so the
recreational
three
uses.
under 6.4.14, it reads that excavation or grading activities solely for residential use, recreational use, or bona fide agricultural use shall be exempt from the special exception procedures. So basically, they're saying you don't have to go through 6.4.14 if it's solely for one of these three uses. And residential might be you are actively building a home in that area. The other, when this was passed, some of the things that we heard is about a farm pond. If somebody has, horses and they want somewhere for their horses to drink, that they could dig a pond.
Okay. Answers your question? Oh, we got another rebuttal.
Yeah, again, I'm trying not to open up the case for debate. I'm trying to focus on the appeal portion of it, and I'll have a lot of chance to ask the staff on it. But you brought up a good point there, because you used the special exceptions, or the exceptions to the rules of why they didn't have to go in front of this board like they did the first time and got denied. So they went to administrative staff, and administrative staff approved the work permit on August 29th. So when you said that the exceptions were for mining, digging for a horse, digging for whatever, for housing, dirt and stuff like that, would you say the difference is a mining operation versus mining on the property? Does that make sense? I mean, you're digging to make the property the way you want it versus having a mining operation. Because I read the rules for the way you have to come in front of this body is if you're going to have a land mine, a dirt mine out there, and you're going to harvest the dirt and you're going to sell it to all the different people. So the difference really would be a mining operation versus changing the character of the land that's in that area. Is that what you're making a point of?
Correct. You understand it completely. So mining, for selling material and having industrial mining in an area versus, for your own use, you're not changing the area. Your horse is not changing the area. Your horse is not bringing in truckloads of dirt back and forth across the school every day.
So it's your position or your client's position that basically you have a mining operation going on out there versus they're doing stuff to the land, and the administrative department made a decision that's not letting you appeal that there's really an operation going on. Is that really
Correct.
Where your case stands?
Correct, yes, because
Okay.
the record itself, if you even look at the applicant's materials, make very clear that this is for resource extraction, whereas 6.4.14 says solely. The word solely is embedded in
Okay.
it.
If I may follow up on my colleague's question on the difference between the August and the January, because I struggle exactly with that issue, so I loved his question. But give me a little bit more information. Was your group aware? I mean, if there was a second application and it went in front of the board, there's signs posted, there's emails that go out, there's notifications. If it's an application that just goes to the administrative department, is there any notification that goes out? Were your clients notified? Was the property notified? Were the neighbors notified?
Nobody on my side was notified. Our notice came actually when our client's members drove by and saw a stop work on the property.
When was
And
that?
they knew that there
When
was
was
supposed
that?
to be no work. I believe the first one was December, early December. I think it may have been around December 5th, and then that was actually posted, I believe, up until February.
Okay. All right. Thank you. Thank you, Mr. Chair.
You got another question, too?
I do. First of all, great questions by my colleague, and thank you for your responses. If I understand, the mining company could not have started work in August of 2025, could they?
I do not. I don't believe so, no.
Okay. When was the stop order issued?
That would have been, like I said, we saw it out there beginning of December. As far as when it was issued, part of the problem with my FOIA is the moment that I was told about this sign, I issued a FOIA early December. And then when that FOIA went out, I only got basically everything up into that date. So I didn't really see, the sausage being made on what was happening with that.
So as of whenever the stop order was issued, they hadn't fully complied with everything needed to do the work.
That is correct. And I heard from county. I actually spoke with county about exactly what that was. If y'all would like to hear county's position on that, you can hear that. But I can say that I myself heard that it was that they had not applied with a lot of the things that they were supposed to already get to y'all on trees.
Okay. For what it's worth, as a lawyer, I would have looked at it the same way you did, that if you had tried to file and maybe this would help my colleague understand and appreciate the Hobson's choice, or the conundrum, if you will. If you had attempted to file an appeal in August, you're familiar with the word being premature
Correct.
or not ripe for resolution?
Correct.
So you would fully expect the court would have said, hey, you got to wait until you did now. Is that your position?
That is absolutely my position.
All right,
And
I
if there
hope
was
that helps my colleague
Yeah.
to my left.
I hate to ask, but you got to follow up.
But also, something else I would say here is in that packet that I handed up to you guys, we were in communication, very early December. If a decision had been made by that point, I will also represent to you that I was told by staff that there was a decision. I called on December 30th and was told that the paperwork is in and a decision might be coming. So that also points to that. But again, I'm aware that I don't have any proof of that. But my proof that I can submit to you guys is that I was talking to staff throughout the months of December, and nobody said, this has already been issued, this is done. Okay. I never heard that. Okay. That's why I was continuing to send these papers. If it had been something else, I would have appealed with the normal form, but I just thought this is forthcoming.
Okay. Any more questions? We thank you for your testimony
Thank
today.
you.
Do we have anyone else to speak in support? Do we have anyone else to speak in support of this? Well, no, that's not. Well, that was it. Yeah. I forgot. Sorry, just old routine.
Okay, so the appeal being heard tonight is solely based on the Zoning and Planning Director's determination that the original appeal to the BZA was not submitted within the time frame allotted by the ZLDR. I'd like to begin by describing the approval process for all development in unincorporated Charleston County with the exception of single-family residential development. First, an applicant will submit a form called a letter of intent where they will describe the proposed use on the property. Staff will review that form and schedule a pre-application meeting with the applicant where the proposed use is discussed, as well as the site plan review process and any requirements pertaining to that proposed use in the ZLDR or any other applicable ordinances. When the applicant is ready, they will submit a formal site plan review application, which will undergo a series of drafts or resubmittals that the Site Plan Review Committee, which consists of staff from multiple departments, responds to with corrections that are found to be inconsistent with the ZLDR. Once all corrections are satisfied, the Site Plan Review Committee will provide a recommendation to the Zoning and Planning Director to approve or disapprove an application. An approval with conditions is often made where certain requirements need to be addressed before site work can begin, such as installation of protective tree barricades. Those conditions of approval will then be inspected prior to issuing a zoning permit to begin site work. The issuance of a zoning permit is the last step before actual work can begin, and it is not the administrative decision to approve or with conditions or deny an application. In the case being heard tonight, the Zoning and Planning Director, based upon the recommendation of the Site Plan Review Committee, made the administrative decision to approve the site plan review case with conditions on August 29, 2025. The underlying appeal regarding the applicability of the exemption based on ZLDR Section 6.4.14D was submitted to the Department on February 10, 2026. The ZLDR defines an administrative decision as any order, requirement, decision, or determination by the Zoning and Planning Director or designee related to the administration or enforcement of the Zoning and Land Development Regulations Ordinance. Based on the letter of intent and the pre-application meeting discussion, the Zoning and Planning Director determined that the proposed use, as it was described in that letter, met the requirements of the ordinance, providing an exemption from obtaining a special exception from the BZA. By approving the site plan review application without a special exception, the Zoning and Planning Director had determined, as of August 29, 2025, that the exemption provisions in ZLDR Section 6.4.14D applied, making this approval the appropriate administrative decision to be appealed. The 30-day appeal window provided in the ZLDR closed on September 29, 2025. The underlying appeal was received on February 10, 2026, more than 4 months after the appeal period concluded. The appellant asserts that their letter dated January 29, 2026, titled Notice of Appeal of Exemption Determination under ZLDR Section 6.4.14D, was the official date which the underlying appeal was filed. However, that letter was not postmarked until January 31st, 2026, and received in the Zoning and Planning Department on February 4th, 2026.
Additionally, the ZLDR provides specific requirements regarding filing of appeals, stating they shall be submitted to the Zoning and Planning Director on forms available in the Zoning and Planning Department. Appeals of administrative decisions shall be filed within 30 calendar days from the date of the administrative decision. The appellant argues that the appropriate administrative decision to be appealed was the issuance of the zoning permit on January 5th. As detailed previously, the Zoning and Planning Director made the administrative decision to approve the site plan with conditions on August 29th. The appellant filed the appeal on the appropriate forms on February 10th. The ZLDR uses mandatory language, shall be submitted, indicating that the proper procedure was followed by staff. Even if the issuance of the zoning permit on January 5th was the appropriate date of the administrative decision, the underlying appeal was not submitted on proper forms until February 10th, 5 days outside of the 30-day window to appeal. The appeal of the administrative decision rejecting the appellant's previously filed appeal as untimely is the only appeal to be considered at this time. The contents of the underlying appeal may only be considered at a later date if it is determined by the BZA that the administrative decision to reject the original appeal based on untimely filing was made in error. The appellant claims that they received actual notice of the zoning permit on January 13th at the time that they received documents in response to a FOIA request. The administrative decision at the time that the appellant sought to appeal was made on August 29th. To the extent the appellant intended to appeal the issuance of the zoning permit, the date the appellant received actual notice of the permit is not relative to whether the appeal was timely filed. The appellant quotes state law throughout their argument. However, state law clearly states that the appeal must be taken within a reasonable time as provided by the zoning ordinance. ZLDR Section 3.13 states, appeals of administrative decisions shall be filed within 30 calendar days of the date of the administrative decision. State law also states if no time limit is provided, the appeal must be taken within 30 days from the date the appealing party has received actual notice of the action from which the appeal is taken. The appellant's actual notice of an action is only relevant when the zoning ordinance does not provide a time limit for appeals. However, the ZLDR does provide a time limit, and therefore the date the appellants received actual notice of the administrative decision is irrelevant. Additionally, if the appeal period did not begin until an appellant received actual notice, administrative decisions could theoretically be appealed many years after they were made. This is not the intent of the 30-day appeal period provided in the ZLDR, and it would be unfair to landowners who had relied on those decisions. To summarize, the August 29, 2025 site plan review approval is the administrative decision appellant sought to appeal. The deadline to appeal that decision was September 29, 2025. To the extent appellant sought instead to appeal the January 5th zoning permit, the deadline to appeal its issuance was February 5th. The underlying appeal was not submitted until February 10th. The appeal was therefore untimely and properly rejected by the Zoning and Planning Director. Therefore, no errors are found in the February 19, 2026 administrative decision rejecting the appeal as untimely. Based on the requirements of the ZLDR, staff requests that the administrative decision to reject the original appeal, BZA 0226000943, as untimely be upheld.
Okay. Is that all? Is that all you have? Mm-hmm. Okay, good. Board members, do we have any questions of her?
All right.
All right, thank you. Ma'am, thank you for your presentation.
Sure.
I'm going to have, trying to be fair to both sides, ask you some of the same questions
Sure.
That I asked the appellant. How will you be prejudiced if this appeal, this application for an appeal was granted? How is a county prejudiced compared to the prejudice to the community and environmentalist?
Well, because the ZLDR gives us specific requirements as far as how long we can provide an appeal period, and then to fairness to landowners, as I mentioned, having these designated periods of time of when they would open and close, make it so that we can consistently apply it fairly across the county. So, the appellant mentioned that they filed on January 29th, but that was the date that they put on their letter. They didn't email it, even though she mentioned that she had been in communication with staff. She still only relied on, paper
I don't mean
snail
to cut
mail.
you off, but
Oh, sure.
I'm trying to get, how are you prejudiced by allowing these folks to have the day in court? Compared the community, the environmentalists, people that are concerned about our community. How is, by letting them go forward, how are you prejudiced? Because if you can appeal and if you won, you wouldn't be prejudiced at all. And I'm not talking about the mining company. I'm talking about how is the county prejudiced by allowing these people to have the day in court?
Well,
that's my first question.
Because the appeal wasn't filed on the appropriate forms or within the time frame allowed, then that, that would be outside of what we are administratively allotted in the ZLDR. After it went through the site plan review process and was reviewed and approved with conditions by that committee, they found it to be in compliance with the ordinance, and so we had no reason to, proceed otherwise.
Okay. Every court decision I've ever seen, the courts, whether it was to Circuit Court, Court of Appeals, Supreme Court, Fourth Circuit Court of Appeals, they don't rely on hyper-technical reasons to toss somebody out. You were aware that they wanted to appeal, correct?
No.
You were not aware that they wanted to appeal?
No.
You weren't aware on February 5th that they wanted to appeal?
I was only aware of the FOIA request that they submitted because they had been in contact with the department asking questions about the stop work order that was issued.
Are you saying you didn't get a copy of the February 5th, 2026 Notice of Intention to Appeal? I think it's dated January 29th. It looks like postmarked
Yes, I
January.
received that.
You're saying you never got a copy
Yes,
of it?
I got a copy of that. I'm
So
sorry, I
you were
misunderstood.
you were aware on February 5th that they wanted to appeal, correct?
Theoretically, yes, I had read the letter, but the ordinance prescribes that appeals must be filed on forms provided by the Planning and Zoning Office.
Well,
that's the only thing that we can go on
Okay.
as a staff member. We don't have the discretion to.
All right. Maybe that's where we come in. But I've never, in my years of experience, ever seen any court that would not let them appeal. What they would do would be precisely what you did and said, well, hey, fix your form. If you don't have the right font or if it's not on the proper form, get it straight. But we're not going to throw out your appeal. If you had notice, you didn't have any prejudice, and it's timely. If the January date that you referenced is appropriate, they're clearly within the time. So I'm struggling with how.
Well, I would.
How you could want to kick them out without giving them a day in court.
So you refer to the January date as being applicable, but the approval was issued on August 29th of 2025. So that was over 4 months prior to when the zoning permit was actually issued. And that's, obviously one of the questions that the appellant has brought up as an issue.
With all respect, I'm not sure I'm getting all the responses that I would have hoped for, but let me just try it one last way and then I'll be done. Would you agree that they gave an unambiguous notice of intention to appeal either dated the 29th or the 31st of January? Would you agree with that? Number one, I think you'll have to agree. You said that
they
you got
provided
there
those dates?
You got it on February 5th.
We received a letter on February 5th. The appeal was filed on February 10th.
The second, well, they filed the first one on the 5th, but it was filed in the proper place. This is the way courts look at it. They filed it with y'all, didn't they? Whatever they filed it with you.
They sent us a letter.
Okay.
So that's not an official filing.
And there was no substantial difference between if they used your form or they used their own form. There's really no substantial difference, is there?
Except for we're required as staff members to follow the ordinance, which
So if I
requires that
understand,
they're
you're
on
relying on kind
forms.
of a hyper-technical basis to keep them from having their court day.
Well,
That's the way I'm seeing it.
We have to apply everything on a hyper-technical basis, so, that's why these things often seem overly complicated, but when it gets down to it, we do have to apply the ordinance as it's written. And, that speaks to the original matter at hand as well.
Okay. All right, one last question, and I'll be done. And I do appreciate you being here and the work that y'all do. I asked counsel if she was aware, as an officer of the court, of any single case of any court where a case has ever been thrown out on the basis that you're asserting. One, if you can, I'm not so much concerned with the ordinance because it's got different parts, but can you cite me one single case from South Carolina that would say that that this is the appropriate resolution to not let them have their day in court?
Our job as staff is not to look at, state
Okay.
case law and see how we can
Well, I'm sure you
affirm
talk-
our side of it. Our part in this is to, defend our decision and let you know how we came to it.
All right, I understand. That's perhaps why we're looking at these things in different ways, because you're challenged by not being lawyers and not knowing what courts do in this situation. Thank you.
Okay, so we have a question from Mr. Jordan.
That word I heard you use, it theoretically, that's not a term a poor guy like me from North Charleston uses on a regular basis. So I know I'm not pronouncing it right. But just for the record, and from my understanding, when you use that word, was that a yes or no?
So I believe I was stating that in the negative. So if, I'm going to restate it.
Thank you.
Okay, so this was speaking to the appellant's argument that their date that they received actual notice that an approval had been issued should have taken precedence and started this 30-day appeal period. But on the flip side of that, theoretically, so in theory, if an administrative decision could be appealed based on, say your neighbor got a zoning permit and you didn't find out for 3 years, that would basically say that when you found out 3 years after the zoning permit had been issued, you could go appeal it. And that's just not fair to that landowner that, they went through the proper process and got their approval 3 years prior. So in the argument that the appellant is stating is that they didn't receive notice that administrative approval had been issued, which is done in our office. I think we had over 300 site plan review cases approved last year. We have tons of these things coming in. We issued, I think, about 3,000 or more zoning permits, so there's a lot of volume. If every single one of those zoning permits or approvals were just kind of open-ended on, well, whenever you find out about it, then that's when your appeal period should start, then that's really not fair to everyone that is going through the proper channels and getting their permits as they're required.
Okay, I appreciate that, but still, was it a yes or no?
I mean, yes or no to what?
That you got your notice or you became aware of it, whichever one you said. I don't use that fancy word, like I said, very often, so I'm confused. Which is it, yes or no?
So I said, if the appeal period did not begin until an appellant received the actual notice, administrative decisions could theoretically be appealed many years after they were made. This is not the intent of the 30-day appeal period provided in the ZLDR, and it would be unfair to landowners who had relied on those decisions.
Thank you.
Okay. Do we have any? Yes, sir.
Thank you. This is a fun case this evening.
It is.
So, does ZLDR define an administrative decision?
Yes.
What is that definition?
Any order, requirement, decision, or determination by the zoning and planning director or designee related to the administration or enforcement of the zoning and land development regulations ordinance.
Is the zoning permit considered an administrative decision?
It could be.
So it could be argued under that pretense that the January 5th date would apply.
That would be if there was no site plan review approval process. So typically, something that would be single-family residential, as I mentioned, that does not go through the site plan review process, that is reviewed, we call it like a front counter permit. Somebody can walk in, if they have the documents that they need, they can apply and hopefully walk away with a zoning permit that day because it goes through a shortened and less intense review. Site plan review is a much different process where it involves different departments so that everybody can coordinate, such as stormwater, building services, and zoning. Everybody can kind of be at the table at the same time and discuss the case, so they're not being siloed and sent in different directions and extending the process. So site plan review does a concurrent review, and they will send out and correspond with an applicant kind of back and forth until all of the requirements have been met, and then they will issue an approval.
And then that approval is what was stamped August 29, 2025 for
Yes.
this particular case. And in this case, since this is under 6.4.14, and it is resource extraction, so that's specifically calling out for mining. That shouldn't be a question. But would that be considered a by right use
Yes.
for that property? Okay.
Yes, if the applicant can demonstrate on the letter of intent, and we are not, here to tell someone that we think that they're lying on their letter of intent, that's not our place. We have them describe exactly what they're trying to do as accurately as possible, and then we will review their plans based on how they have described it. And the way that they described it in this case was consistent with the exemption provisions provided in 6.4.14D.
And so if it's determined to be a by right use by the administrator, there's nothing in Zeldar that calls for a public notice at that point.
No. We do a lot of notifications, but something that's issued based on by right, like I said, we issued 3,000 permits last year, and we certainly did not send out 3,000 notifications. So, that would be too difficult, and also there's no public process that's provided, so that's another reason why there's no notifications that go out.
And so an example, so this board sees a lot of requests for pools within critical line setbacks and buffer areas. And, we do issue permits for a lot of those, good, bad, or indifferent, I guess. But for every other property owner that actually applies to put a pool where they're allowed to have a pool and they're not going to encroach upon that buffer, those never come before this board, and none of their neighbors are ever noticed about that particular action, correct?
Correct.
All right, and this would be similar to that because it classifies as by right zoning.
Exactly,
All
yes.
right, thank you.
Anybody else down here? Ms. Smith? Okay, sir.
Thank you, Mr. Chair. Boy, you've got a tough job. Without a doubt. Because, I see both arguments. But I'm trying to zero in on two things. One is the date that my colleague brought up, the August and the January. But I'm starting to hear a lot of testimony that basically the January date was the final date. Because you said by your own testimony that there was other possibly site plan review. There were still things going on in January before, or maybe December, that really finalized and wrapped this thing up in January. So and you're really not saying no to that. It's one of your arguments. You'd like for us to say the August argument because then January's not even there. And 30 days from August, it's gone. I totally understand you've only got a finite timeline because if you don't learn about something 3 years later, I'm sorry, you're supposed to do your diligence. So I'm zeroing in more in the January timeline. I understand I'm not a lawyer, don't want to be one, and don't play one on TV either. But, if you were having conversations, whether they were by email, you received a letter, it sounds like you received a letter before the 30-day window if the January 5th deadline is that, you were aware of it. So I don't know all the case law, and I don't expect you all to know case law. You're doing your job and things like that. So you received notice of an appeal. I get it. It's a property that is crazy, that it has mining operations under it. I struggle with the idea of how is a homeowner that's next door to understand that there's going to be a mining operation going on next door to them when they already fought it the first time and thought it was over? How are they supposed to understand without forming the group and hiring lawyers and going to file in circuit court? They should be able to come in front of a body, whether it's their county council or something, without a lawyer, and walk up and say, "Hey, I live next door to this thing, and it's not a dig a hole for a horse. It's a mining operation." How are they supposed to be able to do something if a decision was made? And I'm not saying right or wrong. If a decision was made and there's no notice given out, how are they supposed to respond to that?
We would need to amend the ordinance to remove that exemption.
So I agree with that.
So every mining operation would have to come through a special
Because
exception.
mining is what brings out the crowds. People don't want to mine next door to them. So obviously this was a hot topic in the community. And this has nothing to say whether the decision by the administrative or whoever made the decision in the department was wrong or erred. It's just, I think the bigger picture is there's a mining operation going on, and somebody wants a voice. Unless they hire a lawyer and go to circuit court, this is their first chance for a normal appeal. So that's kind of where I am. Not to say that I think things were done wrong or pick a date and stuff. I'm trying to understand it. But then the last point that I need to understand from your side, the administrative side, is, and I don't want to break down the original application versus the second application, but I'm struggling to understand if the first application, and I don't even know if I was on the board in 2023, but if that was denied, and then a staff decision, an administrative decision was made because it fed into 6.2 whatever, or 6.4 whatever it is because of these special exceptions, if it's still a mining operation, if it's the same application, I mean, what was so extreme that changed this application where it didn't have to go in front of this board?
So I'd like to address kind of a couple of things
Yeah,
because
that'd
I
be
think
great.
it'll kind of
Yeah,
paint
that
a
would
good
help me.
picture. So in the appeal document that was filed, the appellant included one of their exhibits. It was,
Can we get it in front of us so we can look at it? It's working? Or?
is there like a page for,
It's only 196 pages.
I know. Well, I saw one on 51 that talked about mining. That's why I brought that up.
okay, so Jenny's going to pull this up.
That helps. Thank you very much.
Sure.
Okay, go ahead. Well, give him a
Oh,
moment.
sure. Okay.
Oh,
So
Mr. Jordan. Well, hold on, Mr. Jordan. We'll get to that. Let him find this.
So the exhibit that I'm asked Jenny to pull up is the site plan review approval letter that states the approved with conditions determination for the site plan review application, and it lists a number of conditions, all of which are the specific criteria in the ordinance that make this project in compliance with the exemption procedure. So the first one is the resource extraction operation shall be limited to 1 year from the date of the zoning permit. The resource extraction operations shall be 2 acres or less, provided that the total accumulated areas dedicated to resource extraction uses on a parcel is less than 5 acres. The special exception procedures in section 6.4.14B of this ordinance shall apply if the total accumulated resource extraction area is greater than 5 acres. No more than 1 resource extraction use shall be permitted on the same property within 1 year from the date of the zoning permit approval for a previous resource extraction use. A sign listing the name and phone number of a local contact for the resource extraction use shall be posted at the Hall Road entrance, and the hours of operation for resource extraction operations shall be limited to Monday through Saturday from 7 a.m. to 6 p.m. So those are the conditions of approval on the site plan review application.
That was much different from the very first application that they brought in front of here.
Yes, because it wouldn't have met those criteria. This one is significantly less as it was proposed to us.
So it was a smaller mining operation.
Yes, that they
That
described
falls
as,
within the exceptions of the ordinance.
yes, as an accessory to a residential or bona fide agricultural use. There were 2 additional conditions of approval, and this speaks to that zoning, the determination of the site plan review approval and why the zoning permit wasn't approved right at that time. Because, and this is very typical for site plan review, we want them to protect all the trees, get all of, those barricades in place, and then we go look at it and we say, okay, everything's protected, you're ready to go, you may now get your zoning permit. So a reversal of a zoning permit in an instant like this does not reverse the approval of the site plan because it still, in our opinion, met all of the ordinance requirements. If there were no site plan review process and it was just a zoning permit issued at the front counter, like I was mentioning, and it was reviewed, for all of the compliance, and a zoning permit was issued at that time, then that would have been the appropriate approval to reverse into appeal. So having the August 29th approval day really changes the applicability of allowing the appeal to come through, even though we still don't agree that it was timely filed. It still wouldn't have undone our approval if the zoning permit was reversed.
It's on page 193 of 196.
And if I could just follow one last.
But she just read it out.
Let me
Great,
get
for the
one
record.
down here from Mr. Jordan first. Mr. Jordan, you had a question, sir?
Before you have that last point, I want to follow up on what you just said, which is, God bless you, which is, he asked, what's the poor person supposed to do?
I'm sorry?
I believe he asked, what's the everyday citizen, poor person, what are they supposed to do? What's the recourse they have? And I heard what you said, which I understand, change the ordinance. Okay, yeah, fine. But here it is, 2026. This issue and any other issue that comes, what are they supposed to do? Just say, okay, you can't beat the system, just walk out that door and downstairs and throw the hands up. I mean, what are they supposed to do? Tell them something.
It would require an amendment to the zoning ordinance because then this exemption would not be allowed if that's what, made its way through county council.
Well, as I said, I understand that. But I know the process. But still, what are we supposed to tell the people? They don't preach the law every day. They don't watch TV court. What do we expect them to think?
Okay. All right.
I had one last question.
Well,
if I could.
let me go down
follow
here,
up
then
on
I'll
that.
come back to you. Let's try to wrap this up.
This will be my last question. So there is no current notification of any neighbors, anything like that, of any mining operation if it meets standard code permit right across the counter for mining whatsoever.
Yes, if the applicant can demonstrate that they meet those specific conditions that I read out, then it is not a process it's exempt from special exception procedure. So it is exempt from having to come before a public body.
Which is exempt from the extra notice.
Exactly.
And if this was to be overturned, what would be the next process? They would hear, what's next past the appeal? Would it be a challenge to the actual decision of the administrative?
So if the BZA overturns, says that the zoning
They can't
administrator
appeal?
yes, that the appeal was filed in a timely manner according to our ordinance, then the original appeal would come before you.
Okay. All right. Thank you.
Was that your question?
Yes, I want to follow up on my colleague DeMar's
Talking to your mic for me.
questions that were very well framed, I thought. But getting beyond the point that, of course, the county does have attorneys that could advise them, I have a concern talking about the swimming pool analogy. People usually only put one swimming pool in the backyard. They're not going to put multiple swimming pools in the yard. Here, for example, and I've experienced this in the past, if you have somebody with 500 acres and they wanted to have a sand mine, but they couldn't get 500, the public was going to be outraged. If I understand what you're saying, they could do 2 acres and get it approved without the public having any input, then two more acres the next year, and 2 and 2 and 2, and get the same thing. And I'm concerned about opening Pandora's box where the public doesn't have any input and people concerned about the environment don't have any input, and I'm still struggling with why you'd be prejudiced by letting them have their day in court.
So each of those additional 2-acre operations that you mentioned, those would have to start back over and go through the full site plan review process again and again. It can only be done on one parcel, and up to 5 acres, I believe, is the designated, okay, I'll read you the condition. The resource extraction operation shall be 2 acres or less, provided that the total accumulated areas dedicated to resource extraction uses on a parcel is less than 5 acres. So they can be approved at that time for 2 acres, and they cannot apply for, if they were to do their 1-year operation, do the 2 acres, they could reapply, go through site plan review to do another 2 acres, but they cannot do any more than 5 total on one parcel.
They could, of course, subdivide the property and get. I mean, I know how it works. They could just subdivide the property, and then they could go on with, what's that, 20, 30 mines without any public having any input.
They'd still have to meet, the requirement showing that it's for residential or bona fide agricultural uses. So there are some other quantifiers, but I mean, I totally understand what you're saying. I'm just stating what our ordinance states, and that's, that's what we as staff members can go by.
So board members, let's be mindful that we're not trying to change the ordinance. We have to understand how the ordinance was laid, and we have to play where this ball is right now, as you like to say it. Okay, I'm going to allow for just one last question, please, and let's keep this minute because we've been going an hour and a half. Ms. Smith.
So you were saying that we need to rewrite the ordinance for you to be able to deny something like this. Did they have to get the special exemption for residential, recreational, or bona fide agricultural use? And if so, how did they meet that special exception requirement?
So that was through the site plan review process where the planners, the zoning administrator reviewed the site plan. They went back and forth, and they were able to demonstrate in that process that it met all of the requirements, and they were able to get that approval.
What sort of requirements? Because it says it's a special exemption for residential use or bona fide agricultural use or recreational use. So that, to me, is written for a certain use of the land,
right? Not
for a mine, but for those uses.
They had demonstrated, and I can't really go into specifics just because this case isn't about that case, but they were able to demonstrate that it was the exemption that it would apply was for future residential use. I'm not exactly sure how that was demonstrated because I wasn't a part of that process, but that was what it was based on.
Thank you.
All right. Very good. Thank you so very much for that eloquent display of all the ordinance and what we have before us. Okay, thank you. Now, board members, at this time, do we have any general discussion among ourselves? Yeah. Oh, yeah, I forget. We've been at this an hour and a half. Okay.
Because she gets to
review.
Rebut.
Okay.
This is public comment in support of the appeal, if there's anyone here in support of this
All right.
appeal.
At this time, do we have anyone to support this appeal present? The appellant. All right, so okay, so let me just say this. I know we had a couple of people to walk in late. If you have not been sworn in, those who have walked in, because it's kind of hard for me to say, I need you to be honest with this. Would you please stand at this time if you have not been sworn in? And think to make a testimony or present facts that are pertinent to this case. If you think you're going to speak and have not been sworn in, would you please stand at this time? We have one. Ms. Working, if you administer the oath, I appreciate it. Okay, thank you. Okay. Do we have anyone to speak in support of the appellant? Do we?
I think they were waiting to be called according to the sign-in list.
No, we're not waiting to be called in. Just when I recognize you. Yeah. Okay, so let me remind you, we have 2 minutes, okay? I need you to please state your name and address for the record, and please tell us why, okay?
Okay.
Very
Good afternoon. My name is Willette Alston Hockaday. I reside at 6586 Patrick Dingle Road in Almondale, South Carolina. And so I'm not here to talk about policy or law because I don't know it. I'm here to speak from the heart. We're talking about placing a dirt mine next to a school, not next to an empty field, not in a remote area, but next to children. So I want to ask the question, one simple question. If this was your son, your daughter, your granddaughter, would you want a dirt mine across from their school? Would you feel comfortable with the noise, the dust, the trucks, and everything else that comes with this in this environment? Because of us, this is not a proposal on paper. This is real life. These are our children. These are our families. All we are asking is to be heard, to be considered, to be protected the same way anyone will want their family to be protected. If it's not good, if it's good enough for your children, then it should be good enough for ours. Thank you.
Hold on for a moment. Thank you. Let me see if anyone has a question for you. Do we? Thank you so very much
Thank
for your
you.
testimony. Do we have anyone else? Well, listen, you're going to have to raise your hand. You just can't walk to the podium. I'm going to have to recognize you, okay?
Line up.
Okay. So after this young lady, I'll take you first, okay? In the blue. Please come on up to the podium. Anybody else that want to speak?
Just let her speak and then
Yeah.
next person.
All right. Please state your name and address.
I
see
am
your hand.
Barbara Singleton, and I live just a half a mile, 9368 Highway 17 North, less than a mile from the mining situation. But anyway, I just want you to understand that the biggest danger here is what we can't see, even if it's that 2-acre residential dirt hauling, whatever skies it's under. But I'm just going to go ahead and call it a sand mining. Sand mining releases crystalline silica dust and fine particle matter in the air. These particles are so small, they bypass the body's natural filters and go straight into the bloodstream and to the deepest parts of the lungs. For an adult, this is a hazard. For a 3-week-old baby, because that's what St. James houses, they got a daycare starting at 3-week-old, going up to 14-year-olds. So for a 3-week-old baby whose lungs are still literally forming, it is catastrophic. Children breathe more air per pound of body weight than we do. They play hard, they breathe deep, and they're closer to the ground where the dust settles. We are looking at a future of skyrocketing asthma rates, decreasing lung function, and in tragic cases, the potential for permanent scarring of the lungs that has no cure. Sand mining brings industrial dump trucks that burn diesel fuels, and while they're still there idling, they're collecting all of these 40 pollutants that the trucks themselves hold. I urge this board to please go ahead and repeal this so-called non-mining project and put our children to the forefront. Let's keep sand mining where it belongs, and that it does not belong anywhere near anybody's school in anybody's community.
Okay, thank you. Let me see if anyone has a question for you. Anyone left? Right? Thank you. So I need to do this in an orderly manner, okay? Thank you. You may have your seat. Just raise your hand and I'll see. This guy in the orange just kind of pokes out at me, so I'm going to let you come next, okay?
Tell them that they're good enough to speak. They don't think they're ready.
Yeah. So, ladies and gentlemen, everybody will get an opportunity to speak, okay? So we're just trying to get through it in an organized fashion. Thank you, sir.
Yes,
Please
sir.
state your name and address
Appreciate
for the
it. My
record.
name is Mike Butcher. I have a property at 8724 Old Georgetown Road. It's approximately 2,600 feet from this location of this agricultural mine. In the map up there, I am a property on the left side of the frame that extends outside the frame. I'm currently building my house at that location. I spoke at the board in 2023 against the bona fide mining operation. I asked you to reject the administrative. I asked you to grant the appeal and reject the administrator's rejection of the appeal, so that as a resident, I may get my time to voice my opinion regarding this. At that time, I would be glad to speak about why I don't think a mine is appropriate there, and that a 2-acre, I'm still struggling with how this is a bona fide agricultural, residential, or recreational need. The letter of intent was not part of what is in the packet. I don't think that the people that requested the FOIA have received the letter of intent yet to understand how this is a bona fide agricultural or residential application. So I do ask that you grant the appeal, reject the administrative rejection, and I will leave it at that. Thank you for your time.
All right.
Any questions?
Any questions over here? No? Thank you so very much.
Thank you.
Thank you. All right, take somebody on this side. I'm going to go back and forth, okay? So, young man with, sir.
Young. Good evening, Chair. Good evening, board members. I want to thank Ms. Milton and the group here because we are in.
If you address everything up towards us, please.
Yes.
Thank you, sir.
I just wanted to let her know. Okay.
What was your name again? Please state your name and address again, please.
Thomas Collerton, Jr. I live at 1250 Tidwin Road in McClernandville.
Thank you, sir.
Tidwin
Proceed.
community is within the confinements of St. James Santee Elementary School. Now, like Vaughan said, I was here before, so this is not the first rodeo because I was on the District 1 Constituent School Board for 31 years until we were fired. So I think what we're going through right now, we do have a failure to communicate. The analogy or the hypothetical that was raised about the neighbor in the swimming pool, I would think that from just past experience that I've seen in my community, if that was a problem with the community, a sign would be put up to say that there was a zoning or a hearing so that as me as a neighbor in that community, I would have due process to bring up, even though if it was 3 years after, I would have due process. In this case, there was no due process. Just like I was on the school board, got fired without any due process. But I'm here as still a member of the school, protecting our children. The first attempt was here, and it was basically the safety of our children. So I don't know why it changed, just because size. It doesn't compute because it's the same things going on. So the project, our efforts back then, we thought that we had put this baby to rest. But now here we are again, and just like the comment was made, I thought the same thing. Another year from now, are we going to come back again? Because I too requested a FOIA. Because when I saw the situation going on at the school, I called my representative on this board, if I can call his name, Larry Kabrowski, and find out what was going on. School official did not know. I wanted to see the site plan. I was told that I need to put in FOIA request because of the close proximity to the school.
Okay.
When I received that, it said that it was 900 feet.
All right. I'm sorry. At this time, your time has expired. Let me see if anyone has a question for you. Anyone on my left? Anyone on my right?
Sorry, I just had one question. Don't I recall you being here 3 years ago?
He just said that.
I thought I recognized you, and you were making this basically the same arguments now as you were doing then. Is that correct?
Yes, sir.
All right. I got it then. I still remember it. Thank you for coming again.
Okay.
Thank you so very much for your testimony, sir. I saw a hand over here with the shades on your head, white shirt.
Hi, my name is David Quick, and I live at 1502 Village Square, and I was among the people who were at the 4-hour meeting back in 2023. I feel like this is a betrayal of the public trust. We made a good case why a sand mine shouldn't be next to a school in Allendale. And we won our case. And then they find a little loophole. They go to the staff. They get the staff to approve it. And there's no notification that the staff, knowing the public interest in this project, the impact it's going to have on children. And I made the case back in 2023, would this mine be approved if it was next to Mount Pleasant Academy or Porter Gould or Sullivan's Island Elementary? And I doubt it would be. I doubt it wouldn't even be considered. So please, grant us the ability to challenge the staff's decision. Shame on the staff for not letting anybody know, considering the public interest. Comparing this to a swimming pool that was built, somebody didn't find out about it 3 years later. That is ridiculous. This is a timely a request for intervention. We did not know that this was going to happen. So please grant our ability to even have an appeal of this. Thank you.
Okay, hold on, Mr. Quick, if you would. Anyone on my left have a question? All right. Thank you so very much, Mr. Quick. Young lady with her glasses there in the hand. I'm going to come to everybody. I'll get you. I'll get you. Pull that mic down a little bit so we can hear you. There you go. Thank you.
Good evening. Sheila Powell, 1121 Portrait School Road, Almondale, South Carolina. The more I think about this, the more I realize it really makes no sense. To think that downsizing the property downsizes the problem. It does not. Those babies that are at St. James Santee School, including my granddaughter, deserves better. And this is a slap in the face. When you're talking about a dirt mine operation that requires heavy machinery entering and leaving the property several times a day, that leads to making the road more dangerous. Mind you now, they're going to interact with school buses that are already having problems with on-the-road accidents, minus dump trucks. There is one entryway, one, that they're going to be colliding. Tell me where that's safe for my baby that's on the bus. Tell me where it's safe to have the debris flying in the air all day long for babies who already have issues such as asthma. Help me understand. A dirt mine, an industrial site. So you can make it sound pretty, but let's be realistic. It's a dirt mine and it's dangerous due to the risk of toxics such as lead, arsenic, and mercury. Help me understand who's going to put their babies next to that, not mine. I need everybody to understand the heart of the community. And it doesn't matter how you try to twist it and move it so that we could see it, but we got it now, and we're going to fight for our rights. This cannot be done. As it was stated by the young man just now, tell me what school in Charleston would you put this by? My child is just as valuable as yours, and I'm going to fight for mine. Please consider the fact this is the worst of situations that can happen near a school. Think about it. They can't even have recess. Think about the dust that's going to be floating continuously 5 days a week. Think about the time. Think about all those factors that goes against what's trying to happen. Traffic hazard does not change because you change the lot size. Dump truck sizes, I bet you, is not going to go down. They're going to be big dump trucks. The sand is going to float regardless of the size. Okay. Guess where it's floating to? Our babies. This cannot happen. Please reconsider this.
Okay.
Thank you.
Hold one moment, please. Let me see if we got any questions on this side. None. We have one.
Yeah, I'm gonna make a statement, and I do want a comment back. I'm hoping all the speakers, including yourself, will focus to help us with the decision that we have to make up here tonight as to whether we open up the appeal process. So one of my questions I had before for the staff was, what is the next step if we were to approve this appeal or not approve this appeal? And they clearly stated if this appeal was overturned or allowed to move forward, then you could appeal the decision that the staff has made on this thing. We're not taking up the account of whether the mine can be there and all those different things here tonight. We're only focusing on the appeal process of whether it's a legitimate appeal. So what I believe I'm hearing from you and from a few previous speakers already is that you want us to approve the appeal process so that it can go forward. And if that is the emotion that we can focus on, then we can focus on opening up the school. I hear you as a concern, as my one vote tonight, about the problems that this operation might be causing. But I can't focus on the school and the babies and all of the dust and stuff. I have to focus on the legislative the decision that the administrative staff was made and their interpretation of the rules. So it's not that there are harsh staff members out there trying to harm the community. Please take into consideration that they're just interpreting the rules and the ordinances and laws. Now, if there was an error made, then that's what the appeal process is for. So what I'd rather hear, if you're in support of something tonight, is that you would like to support that the appeal needs to be opened so that you can fight for your rights. Not all of the cases about the school. So you're losing me when you start talking about all those other things. So would you like to say one more thing, like you support this appeal?
And I think it's already been clearly stated, the reason why you're hearing so much now, we were not included in the conversation before. So we don't know if there's still, I don't know if there's going to be another opportunity.
I understand, but what we're deciding tonight
it is
is
what
whether
it
or
is.
not the appeal is available.
Thank
So,
you.
Thank you, Mr. Chair.
Okay. All right. So I see your hand. I'm going to come to you. I'm going one side to the other. I'm just trying to do it fair. So the gentleman back here in the green, against the wall. So we heard. I hope everybody kind of has a clear understanding of what we're trying to get accomplished tonight, and so let's govern ourselves accordingly with that. Please continue, sir.
Yes, sir. Good evening. My name is Michael Prevost. I reside at 527 Pinckney Street in McClellanville, South Carolina, 29458. I want to go to this gentleman, Mr. Neal, I believe. Point is, first of all, let's say I'm on the board of the Village Museum, McClellanville, representing 350 members of the museum, and our mission is to present, interpret, and conserve the extraordinarily rich cultural heritage of the town of McClellanville and the larger St. James Santee Parish. The town was formed in 1926. The parish was settled in 1703. I have a letter here that I would like to submit. In the interest of time, I won't read it, but 3 points I'd like to make. One is the proposed use of the subject tract as a mine is completely incompatible with the heritage of St. James Santee Parish and its rich agricultural resources and natural resources. Second, I realize this is not necessarily answering Mr. Neal's question, but I will answer it before I step down. ZLDR 6.4.14D, as has been stated, the property does not qualify under that. It is not being used materially for residential, agricultural, or recreational values. And thirdly, to Mr. Neal's point, I support an appeal of this administrative decision and further recommend that the decision of August 2023 stand.
Okay.
Unequivocally.
Very good.
If I might, I'd like to present this
Ms.
material
Clark, if you would get that for us,
to
please.
the appropriate county
So you're
staff
submitting
person.
that to our body for...
and I'm sorry, in the interest of time, that material contains a petition sponsored by the Village Museum and is signed by 180 residents spanning the region from North Santee, McClellanville, Tiburon, and Owendall, and a number from Mount Pleasant in opposition to the proposed mine.
Okay.
Thank you for your time.
All right, thank you. Please hold one moment, please, sir. Any questions on this side? To my right? Yes, sir.
One clarification if I can. Thank you for taking your time to come here. That always means a lot when we have public input. What I'm hearing you say, sir, is that you have 180 of your people in your community that want this appeal to be allowed to go forward. Is that the essence of what you're saying?
Yes, that's essentially what I'm saying. Yes,
All right.
sir.
Thank you. Just wanted to make that clear.
Yes, sir.
All right.
Thank you for your testimony.
Thank you.
All right, young lady, I see you here. Yes, ma'am, you. And then I'm getting you next, okay? All right.
Good evening. My name is Megan Singleton. I live at 15632 Weatherveen Trail. First thing, I know you were talking about the appeal. Did we even settle on a date in which the permit was submitted? Because there was August 29th, and then there was January 5th, and I still don't know if anyone actually was able to come to a conclusion or a consensus of which date was the actual date. On that basis, I don't know how we could move forward with an appeal or with the expulsion of the appeal if we all can't agree on the date the actual permit was approved. Secondly, it took us almost 3 hours to get to the actual exemption that the permit was approved for, which was residential. What I did not hear in any of the conditions was when the residence was supposed to be built. All I heard was there was mining going on, but when under the exemption, when is the residence supposed to be built? And if the residence is not built, then what are the consequences to the operator of the mine for not essentially holding true to the exemption under what they got the permit for? And finally, in regard to the ordinance, the young lady was stating that this went under a full site plan review. It seems a little flawed to me that something that requires something as significant as a site plan review does not require a public notification. So it seems like if there was not something, a significant impact, or you could walk up and do the swimming pool, that if this doesn't require that same procedure, it seems like the public should be notified if a full site plan review needs to be done. To that end, I don't know if we can argue about the validity of the actual ordinance that the zoning department has, but it just seems like if you are going to require someone to do a significant environmental review, that you should also let the public know. And that's all I have to say.
Okay, thank you. Let's see if anyone has a question. I'll start on my left, my right, excuse me, and then my left. Okay.
Can I ask one more question? Did we agree on a date the actual permit was?
So the board, and I'm going to say this respectfully, the board is not here to answer questions. The board is here to hear your presentation.
Okay.
And the board will, part of the evaluation will be to determine which date is appropriate.
Okay.
Okay.
All right. Thank you.
Very good. I promised that I'd come to you next.
The whole place is here. The whole place is here for this one.
Dr. Shar Fitzwater, 2650 Daniels Point Boulevard, Mount Pleasant, South Carolina.
State the name again, please.
Sorry, Dr. Shar Fitzwater. I'm from Mount
Fitzwater.
Pleasant. Yes, sir, Fitzwater. I appreciate the fact that we could hear this and get a chance to give input. I want to support that the appeal be granted. I want to support it for a couple of very specific reasons. One of them is, frankly, the last question that was asked by someone there, I don't know if I'm allowed to name names, seems to me to have gotten to the core point. This was supposedly for the future residential use, and frankly, if they can't put their hands on the document that represents it, I don't believe you have an appropriate decision that was made. I don't believe you have anything that could have started in August or even in January. So I truly believe that this is sort of a slam dunk. If they don't have the documents, they don't have the deal. The other thing that I would say is I come from an insurance background, and I've had to deal with asbestosis. Unfortunately, silica has the same issue. Silicosis is a carcinogen. It's documented, related to all of the health issues. I won't say any more about it other than that they have understated the level of risk for our children, and we need to take care of our community. Thank you.
All right. Please, if you would, let me see if anyone has a question for you. That's okay. Anyone on my left? On the right? Well, thank you so very much for your testimony. I had a hand over here. All right. Yes, ma'am, if you would.
I'm Grace Gasper, and I serve as Executive Director of Friends of Coastal South Carolina. Friends of Coastal
And your
South
address, please?
Oh, I'm sorry, Wilson Cemetery Road, Allendale.
Thank you. And pull them out.
Thank you. Friends of Coastal South Carolina has had a 25-year-long relationship with St. James Santee Elementary School through our education programs. The community clearly remains opposed to this project and continues to have significant concerns for public health and safety, and we share those concerns and ask you for an open, transparent appeal of the staff approval of this project. You made the right decision when you denied special exemption when this project first came before you. Having your decision overruled with no opportunity for public input sets a very dangerous precedent across the entire county. There are so many questions and ambiguities regarding this entire process and the lack of any public notice, even if it wasn't required. We have done the very best we can to respond in a timely manner, and I believe we have done so with the information that was made available. And for the sake of our community and our kids and for the precedent this sets, we would ask that this appeal be granted and this full issue be heard. Thank you very much for the opportunity to speak with you this evening.
Okay. Anyone on my right have a question? Left? Thank you so very much for your testimony today. All right. There you go.
Good evening. My name is Cynthia Diane Gathers, 426 Society Road, and I too was here in 2023. I am here today because I strongly oppose the mining operation next to our elementary school, especially since it happened without public notices. First and foremost, we tried to stop this in 2023, but they found a loophole. How could they allow the zoning property to be exempt? So here we are again. This is about our children, their health and their safety. Mining releases dust and harmful particles into the air that can damage our developing lungs of our children. The risk is high. This site is about 900 feet from the school. That's roughly about 2.5 football fields. That's far too close for an industrial operation. Secondly, the increase of heavy traffic. The risk of the school zone should be protecting our children during their arrival, dismissal, and their recesses. and exposing them to constant industrial vehicles, it's a heavy traffic along the noise disruption from the vehicle, which also interferes with their learning. Schools must remain safe and a quiet place for our children to focus. This community is also a historical Black neighborhood with family-like minds that live generations for generations. Our children deserve some level of protecting and caring for our community. And finally, the lack of public notice is a brief trust. I find this unacceptable. Our community deserves transparency, respect, and a voice in our decision-making for our children and our lives. From my understanding, I think it's roughly about 35 acres. Really? Who's going to monitor them? How are the properties going to be monitored for this mining? I respectfully urge you to halt this project fully, inform the public, and choose a safe location. Our children's safety must come first, even if it was approved by this administrator. It is too close to our school, our middle school. Please oppose this appeal. And if not, then you put it in your neighborhood. Thank you.
Okay,
Any
Ms.
questions?
Gathers, hold on.
Go ahead.
All right. Any on my left?
Yeah.
Mr. Neal?
I believe she misspoke, or either I misheard, because she said she was against the appeal. You would, if you're
I am
against the
for it. I am for it. It just
you're
needs
for
not
the
to go.
appeal
Yes.
to be open.
Yes.
I just want to make
Yes.
sure that's very clear, because
Yes,
you said
very
you were
clear.
against the appeal. I wanted to make
I'm
sure.
not
you-
against it. It needs to open. It should never have been brought back up.
Okay, that's all I
Thank
want to
you.
hear. Thank you.
Okay. Thank you. All right. Do we have anybody over here to my right? Yes, ma'am.
Good evening. My name is Stephanie Robinson. My address, I'm with the Coastal Conservation League, so I'm going to give you the work one, is 131 Spring Street, Charleston, South Carolina. And I am here to speak in support of the appeal. I believe that the intent was made clear, first through an attempt at fact-finding through a FOIA request to get straight to the heart of this matter. And I appreciate that our appeal was actually filed after we made that attempt. Without due process for public comment allowed, I believe that we made that appeal in as timely a fashion as could be done. So thank you, and I hope y'all will consider that.
All right. Let me see if we have any questions on my left. No? Any on my right?
I have a question just to put things in perspective.
Yes, sir.
I've been counting, and we've got something like, the most input we ever had was the last time y'all were here in 2023, and I distinctly remember it. And
That's probably when y'all start getting snacks.
I always keep notes. But by my count, just right now, we've got something like 191 people that are opposed. How many people do you represent that are likewise opposed to, or would want this appeal to go forward and oppose the mine?
It's hard to find out because we didn't.
Give me a rough estimate.
Hundreds.
Okay. All right, I'll go with 100. All right.
Probably more. We did an appeal on Friday to try to get more comments entered online. I don't know how many y'all actually received as a result
So
of that.
we're getting close to 300 already.
Okay.
All right. Thank you.
Great. Thank you.
Thank you for your testimony. All right, I'm going to come back to this side. Anyone else on this side over here? Yes, ma'am. Go to the microphone if you would, please. You have something you want to give to us, is what you're telling me?
I want someone to give you some pictures that I have taken.
And we'll accept your pictures. Name and address for the record, please.
You can see how the things that I took, that I showed them how to, the back of how they did the digging up of the school.
Okay.
You can see a more colorful design of how it did it, of the pit that they already dug before.
Okay, go ahead and just state your name and address for me.
My
first.
name is Miss Clarissa Brown. I live at 466 Drayton Street in McClenaville, and I have some nieces and nephews that go to St. James. If you could see some of the pictures of how they dug up in the sand pits in the back, is further back than you think they are. But then there's have some in the school, which they're just trying to start. You see.
Go ahead.
See how that is right now? If they've done that already, imagine what they're going to do when they do the one on the side of the school. You see? Now, if they started that already in the back, digging as deep as they're going to dig, the deeper they dig, the more they're going to damage the water systems around the school and around the kids. See? Because when you dig a sand pit, you're digging deeper and deeper into the water systems of the school. And that's going to damage the water system, and that's going to damage the water well around the school system. And that's going to make the school get worse as the days the kids being in the school. See, because I know how a sand pit is. Because they dig till they get water. And the more they dig that sand pit, it's going to ruin that system, and they're going to ruin that water system around that school for them kids. Because if they dug that one already in the back, you see on that picture, if they put that one on the side of that school, it's going to do the same thing. It's going to mess that school up, and it's going to mess that whole system up on that section where they're at, and it's going to run on down that area. So I please ask you, do not let them put that there, because you're going to harm those kids in a bad way. I would not like to see those kids get harmed. I really won't.
Okay.
Because the deeper you dig, the more it's going to mess them system up. It's going to mess it up worse and worse.
Okay.
Because I've seen it myself from how they dug on the roads way back in Orndale.
Okay.
Because it's like I said, it looks like a pool when you finish digging all the water because you can't put the dirt back.
Okay. Let me see if anyone over my left have a question for you. No? All right. Did you have any other statements you wanted to make?
Please just don't let them put that there.
Okay.
Because you're going to mess some kids up, and I don't want them kids being hurt.
Okay.
I really don't want them being hurt.
Okay. Nobody wants kids to be hurt.
That's why I like to see them pictures.
All right.
Take
Thank
a good
you.
look at them.
Thank you for taking the pictures. We have anyone on this side want to speak? Okay. Anyone on this side? Anyone left? Anyone else? Oh, okay.
You're still talking about opposed?
Yes.
That are supporting the appeal?
Yes, supporting the appeal.
Supporting the appeal? No,
Yeah.
sir.
Oh, okay. I thought I made myself clear. Okay. So that's it for that. All right. So that's closed. Do we have anyone to support? Opposition to the appeal? Yes, go ahead.
Good evening. My name is Robert Strange, 609 King Street, Mount Pleasant, South Carolina. I am the environmental consultant for the applicant on this. Wanted to put a couple things out there, some misinformation that was around, and answer any questions y'all may have. In the letter of intent, it specifically says the applicant's plan is for agricultural and residential use of the reclaimed mine, thus meeting BZA's exemption. Throughout the planning process, we work with the landowner to design the reclaimed site to add value to the property through aesthetics, recreation, and can be used for irrigation, stormwater retention, and fire protection. This property is zoned Ag 10. A property that is forested like this, forestry is agriculture. So this property meets the criteria of the BZA exemption. The August 29th site plan approval date is in my opinion, should be the date we're working off of. This, based on the approval on that letter, the only conditions left on that to achieve are place tree barricades and pay a fee. We can't pay the fee till tree barricades are placed. And the stop work order everyone's been talking about was placed after 1 day of clearing to place tree barricades. So as soon as I got notice from my client that a stop work order was issued, I called the county and I explained, hey, we're clearing to place these tree barricades because it's in forest and you can't get around to place tree barricades without a little bit of clearing. That was immediately proceed, call us when you're done. So public notice, this was public notice through SCDES. They have a public notice period. Every adjacent landowner is also mailed a notice. So this was not just slid under the rug in front of everyone. It was a public aspect to this. I was not involved in 2023. I wasn't here. I don't know what happened. This application is 2 acres. It's smaller than what I presume was initially done and meets all the criteria of this exemption. That mining ordinance was rewritten a couple years ago, and your neighboring counties all allow up to 5 acres of minings or no public input for any size mine. As Berkeley does a 5 acre, Dorchester, there's no public comment for any size mine. Colleton, no public for any size mine. So when that ordinance was rewritten a couple years ago, limiting to 2 acres, Charleston County is actually more strenuous than any other county that it touches. And mining, for instance, Nucor was just doing a job. Dump trucks were coming from Georgetown because there was no mine in the area. So you look at a dump truck going from Georgetown, South Carolina, all the way to Nucor off Cainhoy Road. That's a lot longer time for a dump truck to be on the roads. More time for that dump truck to tear up the roads, get in accidents. Putting this closer to where the work is actually a safer alternative. We have to finish this within 1 year. By the time we come to resolution on this, we'll probably be about done.
Okay.
The kids are gone for the summer.
One moment, please.
Yes,
so
sir.
really your time has expired. I know we're going to have some questions to give you an opportunity to go a little further, okay?
Yes, sir.
All right. Thank you. Let me see. Mr. Jordan's got his hands up, and he's been patiently waiting.
This is nothing at all against you, but is the applicant aware of this meeting tonight?
Yes, sir.
Why didn't they come?
They are here.
Okay, that's what I want to know. Thank you. That means a lot to me.
Yes, sir.
Okay. Any other?
Mr. Strange, can you describe again the existing uses on this particular piece of property?
So this property is undeveloped. It's zoned agricultural. And under the right to practice forestry, the definition of forestry is extremely broad. But this property is being managed for future timber growth. Timber is agriculture. It's one of our largest exports out of this state and one of our largest industries in this state. Recreation, hunting, bird watching, walking in the woods, that's all recreation. You can't see that from the outside looking in. So there's no immediate building permit in the county's hands right now for that residential, but the reclaimed pond at the end will also provide recreational value and wildlife habitat. It's a short-term use change that will benefit the neighborhood afterwards.
Ms. Smith?
So are you digging the mining for a pond? Is that what you're saying you're using it for, as a pond?
Yes, ma'am. At the end of it, it will be a pond.
Okay, so if it's sand, you're going to have to line that with clay and bring in clay or something, probably, so they
No,
can hold
ma'am.
water? No?
No, ma'am. During this mine, we're actually not pumping the water down, so there won't be any issue with wells nearby or anything. It's a wet dig with no discharge, so no stormwater will be leaving the mine site. And the water table's about 5 feet below the surface, and so it'll naturally fill up with groundwater. There's no chemicals used, nothing, so it will be a pond at the end of it. There's also actually a mine on the adjacent parcel across Lofton Road that's been reclaimed. So South Carolina has no natural lakes. Everything's dammed or dug besides oxbows. So every lake you see in your neighborhoods or around, those were all dug as mines.
So,
and we'll get to your side, I know.
Yeah, no worries.
Okay.
So, Mr. Strange, you've been through the site plan review process before, correct?
Yes, sir.
In previous instances of going through the site plan review process, when would you deem that the county had made a decision on the particular application that you had in front of them or letter of intent that you had in front of them?
Once I got the letter of approval, I've never gotten one without conditions. They all condition, and it all pretty much mirrors the SCDES conditions. But once we get that letter, I go to my client and I say, "You're good to go. Let's get to work."
All right. Thank you.
Yes, sir.
I have a follow-up on his question. So you got the letter, but you don't get the permit until you pay for and do all this stuff. So when did you receive the permit, and what was the date of that permit? Was it the January 5th deal?
So the site plan review approval was the August 29th. At that point, we go in and do the tree protections, and then we have an inspection, and we have to say, okay, they come out and look at it, and then we pay a $100 fee, and then the zoning permit is
January 5th or something like that?
yes, sir. It was paid. We got it on December 30th and paid it on the 30th on our side.
You could literally proceed with your mining operation, your dirt excavation, whatever you're doing out there, the agriculture and all this stuff, as of January 4th or January 5th or something like that?
So, as of the 29th.
Because the 29th of August, you couldn't do it because you still had to accept the special conditions to do, and you still had to do the tree barricades and have an inspection. So there's no way that, unless you're making testimony here to telling me that you could start work on August 29th because you got informed of it on August 29th, your reality date was January.
We can start work for the tree protections and all that August 29th. And then we are at that point told, you are good to proceed with this. Once you get your tree protections in and pay a fee, then you can open the floodgates.
And what was that final date?
That would be we got notice on December 30th of that the tree barricades and everything was good. And then that letter, I guess I don't have a copy of it in front of me, but based on everyone, the 4th or 5th, yeah.
Okay, that's good. I had another follow.
No, go ahead, finish. You got
Go
it.
ahead.
I get my
You're welcome to. All right. I had a comment first, and just maybe this is just common sense, but when I was more actively practicing law, it would seem that unless we were afraid, common courtesy would call for telling your neighbors what you were going to do, just like we would do on a short-term rental. You'd talk to your neighbors, tell them what you were expecting to do. Was there a compelling reason why you didn't communicate with these folks so they would know precisely what you were doing?
No, I wasn't directed to do that. My job was to go through site plan review and get this.
Okay. I'm not trying to put you on the spot. I'm talking, I guess it's a Southern word, y'all. That doesn't mean you specifically, but the applicant. What was the applicant afraid of? Why wouldn't they talk to the neighbors?
In the history of me permitting these, and I've permitted over probably 80 or 90 mines across South Carolina, I have tried about every way to do it under the sun. Go knock on neighbors' doors, talk about it. Nobody wants a mine next to them. There's nobody. Okay. There wouldn't be a mine anywhere in the state if the public had anything to do with it.
Let me go to a second question. I don't mean to cut you off, but I know where you're going.
So how are we going to improve infrastructure, build roads, everything without the dirt to do so? We have to have it.
The second, different. I've represented sand mines before, and we've done things a little bit differently, perhaps. But I understand your point.
Yes, sir.
I want to get to one other thing, and this is important, I think, for everybody. Will the applicant in this case commit on this tract of land, whatever it is, 39 acres or whatever, commit that they will do no more mining than the 2 acres, or are we going to face a situation they're going to do 2 acres this year, and then they're going to try to slip through a loophole and do 2 acres, and then 2 acres, and 2 acres, and 2 acres, on and on? Will they commit to doing only 2 acres on this parcel of land?
And I believe the thing we're talking tonight about is whether or not to hear the appeal, not about the mine itself.
I understand, but I'm asking so I can. I'm trying to understand.
I was hired to do a 2-acre mine, and that's what the letter of intent stated.
So are you saying they would commit or they wouldn't commit?
I can't put words in my client's mouth.
So
one way or the other.
Okay.
I see you.
Yeah, no problem.
You had a.
I did. I lost my train.
Oh no, I'm sorry. No, Mr. Jordan was first. Okay, and I'll come back to you.
I understand your feeling about nobody's for a mine, so why reach out to them? But first of all, wasn't it the right thing to do? And second of all, have you ever thought about the fact that since y'all did not do that, maybe that's caused some of the concern even more in the neighborhood about what your intentions are? So I'm always on the side of what does it hurt to do the right thing? And what impression does it give when you don't?
So when I've tried to do the right thing and meet with landowners, neighbors, and groups that have a vested interest in this, they tend to use the information I give them against me. We leave the table, we shake hands, everyone's happy, we all think we're going to work together, and then I file my application, and then appeal, public notice, Facebook page, sign this petition against this. So, we've tried to come to the table, and we've really
And that
been met.
too, in today's world, but still, you got to still have faith in humanity.
Yes, sir, absolutely.
All right. Okay. Your question.
So you mentioned about this is a 2-year process, 2-year permit, I think.
1 year.
And it's 1 year?
Yes, sir.
And 1 year started January 5th? Or when did the date start? Did it start August 29th?
It's once the year starts once our tree protections and all are given.
So you really have a year from August 29th of last year. So August of 29 of this year, it's over. Is that what you're telling me?
If that's what county staff says the decision is, then yes. And 2 acres, I've dug 2 acres in 6 weeks before, so it's perfectly possible.
So at what process what percentage of job are you done right now? Are you 10% into the process? Is it not dug up any dirt at all, or where are we in the process?
Well, we've been had call after call after call of dump trucks using Lofton Road when there was a fence on it. We've had county inspections, DES inspections, all. So this process has been a little slowed down from normal just because of the amount of opposition about it. News outside, blocking roads, and it's overall. I think we're probably between 10 and 25% done as of today.
All right, that's fine. Thank you, Mr. Chair.
All right. One last comment, if any. No? Okay. Thank you so very much for your testimony. You may have a seat. Do we have anyone else? Do we have anyone else? Very good. Yeah. So at this time, how much time do we have for a rebuttal? It's 2 minutes. Okay. And please pull that mic down and please restate your name and address for the record.
I'm short. I apologize. And first and foremost, thank y'all so much today. The biggest thing that we wanted was the public to have an opportunity to be heard, and I appreciate y'all giving us that tonight. Couple things that I heard that are untrue is, one, that there is no public comment for general mines. Every general mine in South Carolina must be accompanied by something known as a CZC, which is a coastal zone certification. Even a general mine. And in South Carolina, even a general mine, those go on a 10-day notice under DES. So I just wanted to make that point. But the bigger point that I'm going to make here, go straight to timing. I'm not going to take a ton of y'all's time. Friends, do y'all have the packet up there? Did each y'all get a copy of that? If y'all flip forward, not the thing that I handed you, but the packet that the BZA gave tonight.
It's 196 pages, but go ahead.
It is. And if you go to page 63, this one's really important. I don't know if they can put it up on the screen, but it'd be great if they could. Because if y'all look at page 63, it's got this flow chart, and it even has the stamp on the bottom of it. It says that it was approved, 829 approved plans, but it's got the flow chart of the site plan review process. And if you look at the last step of what's considered site plan review, that is obtaining the zoning permit. It's funny, it's stamped 829, but you can't get that zoning permit because the very next page, which is page 64, is the zoning permit, which is dated the 5th. So just take a look at that. This is their own chart that the county has given here. Also, step 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 is actually having the correct tree protection. And we just heard from the applicant that wasn't there. I showed y'all the stop work that we have proving that wasn't there on the site either. So what I would say is that our appeal got in as quick as it could. For a public that didn't know, wasn't given anything, I have worked as hard as I could with my clients to get the FOIA out, to get this appeal out for a process that's not very well defined. that has worked to shut out the public. I thank the BZA for being the ones that heard them in 23, and I thank the BZA for being the ones that hear them tonight. And I ask that we can continue this discussion with our appeal next time. And I appreciate y'all's time tonight.
Point of order. I believe you said name and address again.
Did she not state her name and address?
My name is Lauren McGill Milton. I'm with the South Carolina Environmental Law Project. Our business address is 510 Live Oak, Mount Pleasant, 29464.
Thank you, ma'am.
Yeah.
Okay. Hold on one moment, if you would, Ms. Milton.
Please.
Anyone on this side have any questions of Ms. Milton?
Yes.
Okay. Yes, sir.
Can you clarify something for me? Because I think I heard Mr. Strange testify that the DHEC general permit for mining did go on public notice, and you're stating that it didn't.
The general mine, like in South Carolina, it will go, yes, it does go on public notice. I thought he was saying that there usually is no process, but the general mine and the CZC both go on public notice, public comment.
Yeah, I believe this one did as well at that time.
At that time, but I would also urge you about some of the other things about this mining permit. If you have a chance to look at the underlying case and all the pleadings in there, and some of the things that were brought up at the 2023 BZA about the mining permit, I think that would be enlightening. Yeah.
Okay.
I won't abide by my 2 minutes, but I'll just.
Just to follow up on moving the timeline from August 29th to January 5th or 4th, whatever that date is, and I appreciate you pulling out page 63. That's actually a very compelling argument that you're making there. I'm now interested in the argument or explanation of, let's say it's January 5th and you have 30 calendar days from January 4th to January 5th to use the proper form. And again, I'm not a lawyer, so I don't know if it had to go on certain colored paper or something font, whatever. You sent a letter and you didn't email it, you didn't send it certified or whatever, and the county got it. And then how did they notify you that it was not a formal appeal, that you had to use their forms? And what timeline did you take to get that done?
So when I was given the proper form, they received it then the next day. And that is reflected in their packet from once I received the form.
So you were notified back on February 4th or something like that?
I believe it was the 9th, and I believe that it was over email rather than mail, and so I got it into them by email. Once I understood that's preferred format, and that's how they want it, they got it.
Okay. So you did that the next day?
Next day.
Okay. Thank you, Mr. Chair.
Okay. That brought up another question. And I wanted to just make sure we had a complete record on this. I think the law says that if you're not in technical compliance, they notify you. You have an opportunity to promptly respond. I just wanted to confirm this, that once they were telling you that, well, you didn't file on our form, and as my colleague said, maybe it wasn't on pink paper, it was on white paper or something like that. As soon as they told you that they felt like you needed to do it, put the application for an appeal on the form that they wanted, is it correct that you promptly did that?
That is absolutely correct.
All right. Within days?
Within like the next, as soon as I knew that that's what it was, I made sure to go ahead and comply with it because, like you said, I know South Carolina law, and there is a case, Ware versus Beaufort County, and a good faith filing followed by a procedural supplement should not be treated as a jurisdictional nullity.
And that's what all the law I've read seems to say, that you handle it properly.
Correct.
All right. Thank you.
Thank you.
All right.
Anything further?
Any more questions? We're good? Thank you so very much.
Thank you, guys.
All right. Case is closed to the public, and I almost need a break, but we got to see it through. Board members, do we have any general discussion?
I have a question for either attorney or staff attorney.
Well, that was the first thing I should have said. Question of staff.
What is is there a procedural vote where it's 50% plus one for us, because there's 6 people here tonight, 6 voting members here tonight, or is it 2/3, or what is it's 2/3. 2/3 to overturn an administrative appeal, which would take 4 votes out of 6. Correct. So it would take at least 4 to turn it over. Okay, thank you.
Any other questions on this side? For staff? Any questions of staff?
I think this will be discussion first.
Okay.
Unless there's gonna be
Any, well, that was, any questions of staff? Anybody have questions of staff? Okay. So now, do we have any general discussion?
If you don't mind me leading out a comment, I feel for staff here. This is, and the staff is put in a terrible situation of trying to thread a needle here to serve a landowner at the same time adhere. They're not the ones writing the law. The ordinances are written by county council, and if there's any pointing of fingers or anything, you point them at your county council people because they're the ones that have written this law, or lawyers have written this law. So I just feel that for my one vote, and especially if it's going to take 4 votes to appeal, I think that there's some mistakes have been made by a lot of things out there, and it's not any finger pointing. And I just think that the greater good here, if there's nothing wrong with this mine, if there's nothing wrong with this application, then appeal for whatever the next step of the process is that brings more public opinion in, public comment in, looked at what this, people have said loopholes, people have said that I'd like to understand more about the first application versus the second application, how it's different if it was phased in. I don't know the mining rules, but it sounds like it's clearly a mining operation out there. So I don't see why that there is any problem with opening up Pandora's box and looking at this whole process. This is one of our most full courtrooms we've had here, public comment rooms. This is a significant area. I wouldn't want it in my backyard, but at the same time, I would like to have the voice, and I would not like to have to hire a lawyer to bring it. The general public should be able to come up and say, "Hey, something's wrong here." At least peel back the onion and look at it. Now, if we disagree and say it's still okay, that's fine. But I think we should be hearing this appeal, and I don't think it's anything against staff. I think they interpreted it the way they saw it was supposed to be done, and maybe there was some stuff, maybe there were some mistakes made, maybe the staff changes, things like that. So that's how I feel.
Anyone else have a comment, statement they'd like to make? General discussion? Oh, I'm sorry.
I was going to echo what my colleague to my right had to say. I hope I didn't appear too harsh regarding my questions to staff. I'm mindful and cognizant and respectful of the burden put on them, and when the county puts a burden on staff to interpret the law, it's just problematic, and that's why we're here. If an honest mistake is made, and I don't think it's anything but an honest mistake, if an honest mistake is made, it's our job to correct that. So I would agree with my colleague to my right. I would give I'm convinced as a legal matter that the people that want to allow this appeal to go forward, they're correct. They're correct emotionally, but more importantly, to my way of thinking as a lawyer, they're correct. They're absolutely correct as a legal matter. So my motion, if I'm allowed to make it, is going to be to allow the appeal to go forward. I'm convinced that this is only fair. The best disinfectant is sunshine. Allow people to be heard. They have concerns about safety. They have legitimate concerns about the environment, and I think they should be allowed to be heard, especially when the law is so much in their favor.
Can I say something before you make your motion?
I'm ready.
We're
to
having
make a
discussion.
motion.
I didn't ask for a motion yet, but yes, go ahead.
I just wanted to simply say that we have a great staff that does great work with good intentions, and I applaud them, and I have so much respect for them. So this case or any other case, it's never the staff. And I hope y'all don't think that, because I understand that you're carrying out what you're given. So it's tough on them, I realize that. So I'm with you.
Any other okay.
Mr. Chair, I'll probably be the lone dissenter once a motion is made, and it's not because I have anything against the community that's affected by what could potentially be built on this property. Where I'll land on this is just a matter of the process that's been clearly established by the county within Zeldar and what's allowed and what's not allowed. And when We have a Zeldar that defines an administrative decision the way that it does. We have a document that is stamped August the 29th, 2025 that has the administrator's decision in it. I think it's fairly clear that the intent for the date of the approval of the letter of intent was August 29th, 2025, and therefore the appeal had to be filed by September 29th, 2025. The January 5th date is irrelevant in my mind. And you know, we have zoning laws in place for a reason. And if you don't understand what your neighbor can do on their property, I would encourage you to go to Zeldar and look at the use regs to see what's allowed and what's not allowed. And if that needs to be changed, that has to be done through the Planning Commission, through the County Council, not through the BZA. That's not our job up here. And so while I know it's not popular to have a mine in this location, I know it's not the most desirable spot for the neighbors of this particular mine. I've got to stand by what Zeldar says. That's what I feel we're called to do as part of this board. So that's my position.
Okay. I just have a general thought too. It's just kind of hard for me to figure out whether August 29th or January 4th or 5th lies and where that ball lies in this court. For us to take action. I'm kind of tethered on either side, to be perfectly honest, because it's a matter of timing, and you can't keep it out there forever. But nevertheless, we have to make a sound decision today, a resounding decision today on how this will flow and how we interpret it, regardless of what staff has done in the past or is doing currently, and what is best for the community. So, any more?
Mr. Chairman, I follow up on that. I think you've hit the nail right on the head. I mean, I think this whole appeal decision, taking the mining project out of it, and it's clearly the decision to open up the appeal on whether there was proper notice, proper record given in January. And that's why I stuck with, I was literally on the August 29th date for a long time until I heard the testimonies back and forth about, well, we notified them. We told them that the appeal wasn't on the proper form. Well, if it was wrong and the date was really in August 29th, then why did we respond and say, hey, put it on the right form? If it didn't matter, it didn't matter. Mm-hmm. So my final straw was, hey, they sent back a notice saying if you put it on the right form, then the appeals could be heard. And then they came up with a decision, and that's where I think the mistake was made. I think if the staff would have sent back something saying, hey, this date was back in August, it's a long time ago, we shouldn't have done anything, I think it would have been over. And at least for my vote, that's where I would have been, is August 29th. So that's kind of how I ended and moved to that date. So just thought that might help.
Yeah. I mean, I'll just reiterate that I work in a world where we deal with permits all the time, and these permits are issued with special conditions. And if I get a permit for something on September the 29th, 2025, and I don't want to construct that until the year 2030, and that permit hasn't expired, it's still a valid permit. And the people that were opposed to it would have had to appeal that permit within 30 days of issuance. No, and that's why I stand where I stand.
No, I totally understand.
All right. Any more discussion? Any more discussion? All right, board members, I need a motion to either support the appeal or
The motion is to either uphold the administrative decision. The motion has to be either to uphold the administrative decision or to deny it.
Okay, so if you've heard it from our attorney.
What's being appealed is the administrator's decision. So either you uphold it and they do not get to appeal, or you overturn it and the appeal goes forward.
Oh, okay. One more time, because I want them to hear it. Please. I know you got a cold, but one more time.
What has been presented before the board is only whether or not the administrative decision is correct. So either the board will uphold that decision or they will overturn that decision. If it is overturned, the appeal can go forward. However, the county could step in and can actually appeal the board's decision. So this is not over.
Mr. Chair, I'd like to make a motion if I could.
The chair recognizes.
Now I'd like to make a motion to uphold the administrator's decision that the appeal was not filed in a timely manner.
Okay. We have a motion that's been made. Do I have a second?
We got another motion?
You can second a motion and still vote against it.
Well, I need a second.
Then the motion dies.
Then the motion
Somebody else
dies.
can make a motion.
Yeah.
If you don't get a second.
Okay, so I still need another motion.
All right, I'm prepared to make a motion, Mr. Chairman.
Okay.
I would move that we oppose the administrative decision, grant the
overturn?
relief sought by the appellant, and allow the appeal to go forward.
Overturn the
Overturn.
If I would overturn the administrative decision, grant the relief sought by the appellant, and allow the appeal to go forward.
Okay.
I'll second.
Okay, you have a motion that's been properly moved and second. All those in favor, please indicate by saying aye and raising your right hand.
Aye.
All right, those opposed? It carries. All right, so at this time, we will take a 10-minute recess, and then we will reconvene at that time.
That way we come back.
Y'all have a good night.
Okay, are we ready? Who we missing? We're not missing anybody. Are we ready on my left? Are we ready on my right? Okay, we will get started again. I thank you for your patience. We've had a long case to start off with. So our next case is case BZA 03-26-00958, and Ms. Working will administer this case for us.
Okay. The applicant, Latanya Leachman, and the property owner, Gopal Patel, are requesting a special exception for the on-site sale of alcoholic beverages, beer, wine, and liquor in association with a proposed restaurant use on the property located at 10475 Highway 78, which is TMS number 385-0600024, in the north area of Charleston County. The subject property and the parcels to the east are located within the Community Commercial CC zoning district, while adjacent parcels to the south and west are located in the low-density residential R4 zoning district. The properties to the north across Highway 78 are located in Dorchester County. The 2-acre property contains an existing 2,400 square foot building with associated parking. The property is currently in the site plan review process for the proposed restaurant. Here's a location map of the property in the north area. The ordinance requirements for alcohol sales. Because this is an alcohol sales case, it is a 500-foot radius. It's a little bit bigger. Aerial maps. We posted the property on April 15th. A couple of photos of the property and the adjacent properties. Highway 78, the site plan, and the plat. Regarding the approval criteria, we stated that it may meet all approval criteria. The board may approve approval conditions or deny the request based on the board's findings of fact unless additional information is deemed necessary to make an informed decision. In the event the board decides to approve the application, we have 2 suggested conditions. 1, prior to zoning permit approval, the applicant shall complete the site plan review process. 2, the applicant shall comply with all applicable requirements of the state of South Carolina for alcohol beverage sales and shall provide proof of state approval to zoning and planning staff prior to the issuance of the zoning permit. Any questions?
Any questions of staff? Yes, sir.
I shouldn't do this, but I will. Ms. Working, is the site plan review process completed when the administrative decision is? I withdraw that question. No, there were no.
They have not been approved by site plan review yet. One condition of approval is that they have to go through y'all first. So
there were no comments.
Go to the next step.
No comments opposed to this one, correct?
That's correct.
Right, thank you.
Yes, sir.
Yeah, on site review plan for alcohol and stuff, is lighting of parking lots and stuff like that, is there requirements that they have to adhere to or something?
Yes. So they're following all the lighting requirements, landscaping.
Okay, so that's all lighting requirements. That's what I think about. Okay.
But they are using the existing building, but they are adding landscaping.
Okay, good. Yeah. All right, thank you, Mr. Chair.
Anyone else? Thank you, Ms. Working. Is the applicant present? Very good. Please come forward. Please state your name and address for the record, and please tell us why we should approve your application.
My name is Latanya Leachman. My address is 550 Mountain Laurel Circle in Goose Creek, South Carolina.
Did you swear in?
Yes, sir.
Good. Please proceed.
So I'm submitting an application. Once again, it is an existing building. I'm opening up a family-friendly restaurant in an existing location. I know he spoke on lighting. I actually had redone the parking lot and had Dominion Energy actually come out and put street pole lighting in the parking lot as you enter in and the surrounding. So therefore, the proper lighting is actually there.
Relax. You're doing a good job. Come on.
No, I wrote a statement. I was going to read it.
Go ahead. Read it.
So our concept is a full-service restaurant focused to provide quality dining experience to the community. The sale of alcohol will serve as a complement to our food offering, not the primary focus of the business. Our goal is to create a welcoming, family-friendly environment where guests can enjoy meals in a safe and well-mannered setting. We understand the importance of operating in a manner that respects both the surrounding community and local regulations. To that end, we have implemented several measures to ensure responsible and compliant to all operations. All staff members will be trained in responsibility and alcohol safety. A strict ID verification procedure will be enforced. We actually bought the ID scanners, so therefore that it would tell you whether they're old enough, if the ID's fake, if it's been tampered with. We also will maintain a clear policy over service to ensure all guests are served responsibly. In addition, we are committed to maintain a safe and orderly environment both inside and outside our establishment. We will have appropriate security measures in place, including staff oversight and surveillance to prevent disturbance. Noise levels will be carefully managed and will not permit loitering or disturbance to the surrounding properties or any guests. We have also taken into consideration parking and traffic flow to ensure our operations do not negatively impact the neighbors, businesses, or residents around our location. Furthermore, we are dedicated to being a positive addition to our community. Our restaurant will create more local jobs and opportunities and economic growth while offering safe and enjoying a great dining experience with the added addition of alcohol. And that's all I have.
Very good. What kind of food you going to be serving?
Seafood with a mixture of soul food. I currently have an establishment in Somerville called Plush Barn Grill. I have had that establishment for 5 years now, and I'm moving to a different location to have more space.
Okay. Okay. Well, good. So do you have alcohol at your current location?
Yes, sir.
Tell me about these readers. I'm curious now. You open my eyes to something now because young kids with fake IDs is really big. And
We just had some last weekend.
wow. Okay.
It happens.
And what type of alcohol do you serve?
Beer, wine, and liquor at my current establishment.
Okay. You hadn't had any problems?
No, sir.
Okay. Okay. Let's see if anybody else have a question. Anyone on my left? Anyone on my right? Okay. Well, thank you for your testimony.
Thank you.
All right. Do we have anyone else to speak in support of this application? You want to speak in support of the application? I saw your hand. Okay. Please come forward. Please state your name and address for the record.
Good evening. My name is Drady Coaxum, and I live at 9907 Livingston Drive in Latson, South Carolina. I'm like 3 minutes away from this location. I met the applicant and just driving by, saw them doing work out there, and I think that this is going to be good for the community because we don't have much sit-down restaurant, family-style restaurants in the area, and I think it'll create a vast opportunity of jobs for people in the area as well as different cultural foods and things that we can have that we won't have to drive so far, possibly.
Okay.
That's all I have.
Good. Let me see if anyone has a question for you on my right, on my left. Thank you so very much for
Have
your
a great
testimony.
evening.
Yes. Do we have anyone else to speak in support of this application? Do we have anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any questions of staff? Do we have any general discussion? Very good. I need a motion to approve or deny this case, please.
Mr. Chair, in the matter of BZA 0326000958, I would make a motion that we approve this request, that one, it is consistent with the recommendations contained in Charleston County's comprehensive plan and the character of the underlying zoning district will, I hope I'm on the right case here, will not be, the character of the underlying zoning district. Is this different than our normal criteria? Is that what's throwing me off?
No.
No. Sorry.
okay.
I just want to make sure I'm on the right thing here. Okay, sorry. Sure. That it is consistent with the recommendations contained within Charleston County's comprehensive plan. As the applicant has stated, the service of alcoholic beverages is consistent with the intent of the zoning district and the recommendations of the Charleston County plan and encourages compatible commercial services. So we meet that criterion. At 2, it is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. So in addition to what the applicant has provided, we've had no letters in opposition to this particular request. In fact, we've had one in support that lives in that community, so we meet that criterion. That 3, adequate provision is made for such items as setbacks, buffers, to protect adjacent properties from the adverse influence, and the applicant has indicated they're installing lighting and everything else to be required to make sure we meet that criterion. For criterion 4, that where applicable, it will be developed in a way that will preserve and incorporate any natural features. In this particular instance, the applicant is repurposing an existing structure into a new restaurant, so we meet that criterion. That 5, it complies with all applicable rules, regulations, and standards of this ordinance. Again, we meet that criterion given that this is an allowed use within this particular zoning district. That 6, vehicular traffic and pedestrian movement on adjacent roads shall not be hindered. There's been no indication there'd be any interference to traffic, so we meet that criterion. In making this motion, I would include the 2 special conditions recommended by staff.
Very good. Do we have any second? Okay, we have a second. Any general discussion? Very good. We have a motion that's been properly moved in second. All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. Congratulations. Your application has been approved. Within 10 days, you'll be getting information from our staff letting you know the next steps in the process. I'll be over there and I'm going to come and get some food now. I don't want to be disappointed. I'm just messing with you. But thank you and good night. So our next case is case BZA 0326-00959, and that will be done by Mr. Hare.
All right. The applicant and property owner, Aaron Marone of MI3 LLC, is requesting a special exception to establish a short-term rental property extended home rental at 1820 South Grimble Road, TMS number 334-1100090 on James Island in Charleston County. The subject parcel, along with adjacent properties, is located within the Special Management S3 zoning district. According to Charleston County records, the property contains a single-family residence constructed in 2025 with 4 bedrooms. The applicant proposes to operate the residence as an extended home rental by offering all 4 bedrooms for short-term rental use, accommodating a maximum of 10 guests and providing 6 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance, ZELDAR. The 2 parking spaces located within the garage will remain clear and available for use by the STRP guest. As you'll see in the table below, bedrooms 1, 2, and 3 will have a maximum of 2 guests allowed in there, and bedroom 4 will allow a maximum of 4 guests, totaling 10. The property owner has indicated as well that they will manage the rental operations themselves. Since the property is not owner-occupied, it does not qualify as a limited home rental, and it must be reviewed as an extended home rental under ZELDAR requirements. This is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the S3 Special Management Zoning District. The 300-foot radius map, aerials. We posted the property on April 15th of 2026. Here are pictures of the subject property, single-family residence and its parking, pictures of surrounding properties, South Grimble Road, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, the 2 parking spaces located within the garage shall remain clear and available for the use by the STRP guest. Is there any questions?
Yeah, I do. I notice he has all the parking outside. So it's not counted on the inside in the garage?
The 2 spaces that you see here on the site plan, those are inside the garage right there.
Oh, okay.
These
okay.
4 on concrete, yep. Outside the
Okay.
garage.
Oh, it looked fun. Okay.
Yep.
Thank you. Any questions? Okay.
Yeah, Mr. Hare, I appreciate you picking up on my colleagues' comments over the past couple of meetings and putting a special condition in here, requiring that the garage remain clear.
Yes, sir.
It took a lot of work for him to do that, too. That's why I had to ask that question. It looked kind of fun. Okay. Thank you. Come on up. Please state your name and address for the record.
Hello,
and please
my
tell us
name
why
is,
we should support.
Iran Moran. I live in 2245 Portside Way in Charleston, 29407. About this property, 1820 South Grimble. It's a 2,000 square feet, 4-bedroom, 2.5 bathroom, newly constructed house. 0.34 acres. It's fully fenced in the back. Got a lot of trees as a buffer too in the back. The driveway is very large, so there's even more than 6 parking spots. A little bit about us. We self-manage all our properties in Charleston. We have a camera, so we monitor guest behavior, make sure everything is good. And we have strict policies in place to prevent unwanted use of the property. That's pretty much it. If you have any questions, or I'd be happy to answer.
Do we have any questions?
I had a couple. Thank you for gracing us with your presence again. Nice to see you. As always, you've done a good job. I just need to check these things off the box, so to speak. Sewer or septic?
Sewer.
Okay,
Yeah.
good. Second one is garbage. And my background being on the Isle of Palms, people come in at different times and they leave when
So we always get an extra can. So we have 2 cans of regular trash, and is that what you asked about?
Well, what I was thinking about, who takes the trash cans out to the street? Who takes them back?
So we have a notice for the guests, but we kind of like come and check after them. We tell them when it's trash day. They get a message, and there's a notice in the property when trash day and recycling. So they know to take it out. But if they don't, for some reason they forget, then was that the question?
Well, I think so. But generally you only take out the trash on certain days, and you got to bring it in. If they are there or they take it, and that's not a pickup day, who takes it out to the street on the appointed day, and who brings it back so it doesn't get knocked over?
So if the guests are there, they usually do it. I think James Island is Monday or Tuesday. Usually it's weekend bookings and they leave, and then we just do it. Or the cleaners.
Okay. What you're telling me, you're taking care of that to
Oh
ensure
yeah,
that the garbage
we have 2
is-
cans too
cans
per
are-
house, so there's never a problem. We always get an extra can, pay the extra money.
Okay. I was just not trying to give you a hard time.
No,
just
no, no. It's
checking
all
off the boxes
all
to
good.
make sure that the
problem.
trash cans aren't out there.
Oh,
Dogs
no.
don't knock them over. Coyotes, raccoons, whatever. Okay. Thank you.
Yeah.
Anyone else? Thank you, sir. Do we have anyone else to speak in support of this application? Do we have anyone else to speak in support? Do we have anyone to speak in opposition? Very good. Case closed to the public. Board members, we have any questions of staff? Any general discussion? Therefore, I need a motion. Yes, sir.
Mr. Chair, in case, I guess it's 03-26-00959.
Yes.
It's an application for a special exception for short-term rental, extended home rental. I make a motion that we approve the request. Jurisdiction is proper. The requirements are set forth in Zelda Chapter 6, and in particular, the criteria set forth in 6.82C1 through 3. This property sits on a large, number one, property sits on a large lot. It's compatible with existing uses. There's no homeowners association that's a part of the subdivision. There's an empty lot on one side and many different types of houses in the area, so this won't affect the character of the neighborhood. Number two, adequate provision is made or exists for setbacks, buffering, fencing, landscaping, et cetera, to protect the neighbors in the community. Again, this property is fully fenced. I'm satisfied that there's a 6-foot fence. And the property's only occupied 40% of the year, so it's not creating a terrible burden on the community. Number three, the proposed use complies with applicable rules, regulations, laws, and standards of this ordinance. And staff has made recommendations. I think there are two or five? I'm trying to. There are 5 conditions that are contained, and I congratulate Mr. Hare for making sure that we were all protected. So that's my motion, subject to the 5 conditions recommended by staff.
Very good. Do I have a second? All right, Ms. Smith with the second. Very good. All right, any discussion? All those in favor, please indicate by saying aye and raising your right hand. 1, 2, 3, 4. It is unanimous. Congratulations. So our next case is BZA 03-26-00960.
All right. The applicant and property owner, Aron Marone of MI3 LLC, is requesting a special exception to establish a short-term rental property, extended home rental at 1822 South Grimble Road, TMS number 334-1100055 on James Island in Charleston County. Subject parcel, along with adjacent properties, is located within the Special Management S3 zoning district. According to Charleston County records, the property contains a single-family residence constructed in 2025 with 4 bedrooms. The applicant proposes to operate the residence as an extended home rental by offering all 4 bedrooms for short-term rental use, accommodating a maximum of 10 guests, and providing 6 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance ZELDAR. The 2 parking spaces located within the garage will remain clear and available for use by the STRP guests. The property owner has indicated that they will manage the rental operations themselves, and since this property is not owner-occupied, it does not qualify as a limited home rental, and it must be reviewed as an extended home rental under the ZELDAR requirements. This is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the S3 Special Management Zoning District, the 300-foot radius map, aerials of the property. We posted on April 15th of 2026. Here are pictures of the subject property, single-family residence and its parking, pictures of surrounding properties, South Grimble Road, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the Board decides to approve the application, the Board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, the 2 parking spaces located within the garage shall remain clear and available for use by the STRP guests. Is there any questions?
Yes, sir.
Just looking at their parking layout, site plan, looks like one of the last car spot is going over either a setback line, doesn't look like a property line, but then that's not the street at the same time, is it? I can't really understand. Is that a long driveway or something? What is that?
Yeah, I believe that's the shared driveway between the two properties off of South Grimble Road, and there's a easement right there, and so it's not a right of way, or
so that car that's sticking out into that shared access point is not an issue?
No, sir.
Okay.
Yeah.
As long as you say. Thank you, Chair.
Anyone else? All right, ready for the applicant again. Please state your name and address for the record.
I'm Iran Moran from 2245 Portside Way, Charleston, South Carolina, 29407. This is an identical property like the prior one, so 2,000 square feet. They had a special buy one, get one free, so we got both. And 4 bedrooms, 2.5 bathrooms. The driveway on this one is really big. You can probably fit 8 cars over there, and it's a lot bigger than the one in the house in the back. Just to answer your question. It's also fully fenced. We have camera on this property too, so we can make sure the guests are behaving. And that is pretty much it. Same thing. 1/3 of an acre.
So both of these houses you probably closed on the same time, I would imagine.
Same day.
Same day. And they're pretty much identical.
Same thing.
Same plan.
Same layout.
Wow, different color.
The garage is just a little bit different. Where the one in the back, the garage is in the front. This one, the garage is on the side. But the layout inside is the same.
Yeah, that's what I thought. You had a question?
No, sir.
Okay. Anyone else have a question? Yes, sir.
Just trying to keep my mind sharp after that first meeting. What does the MI stand for? Because I keep having Mission Impossible.
Moran Investments.
Okay, good deal. I'm looking at MI3, waiting for Tom Cruise to come out. And how many more of these do you have in Charleston County that we get to hear over the next couple of months?
Maybe one more is coming.
Okay. All right. Good deal. Thank you.
Anyone else? Thank you. We have anyone else to speak in support? Anyone to speak in opposition? Case closed to the public. Board members, any questions of staff? Any general discussion? I'd like to have a motion to approve or deny this particular case. You going to get it for me again?
Since I did the last one, I'll do this one.
Thank you, sir.
Familiar with the applicant. He does an excellent job making his presentation. Staff likewise has done an excellent job with their investigation. And thank you again, Mr. Hare. I would move to in BZA 03-26-00960. I would make a motion to approve the application for a special exception, short-term rental, extended home rental. Basically, it's on the same basis as the previous case. The criteria are set forth under Zelda Ordinance Chapter 6, in particular the 3 conditions of 6.8, 2C, 1 through 3. This is compatible with existing uses in the vicinity and will not affect the general welfare or character of the immediate community. I think in this unique case, I can reference what we did before in the previous case that this is compatible with the existing uses in the community, no HOA, and will it's a large lot. There's no HOA. It isn't part of a subdivision. There's an large empty lot on the side. It's typical to the case we just heard, which was ended in 00959. Number 2, adequate provision is made for and exists for setbacks, fencing, and that sort of thing, and as well as for noise. And this property is only occupied for 40% of the year. It'll be vacant for the remainder. Number 3, it complies with all applicable rules, regulations, and standards and such as required by law. I would make this motion subject to the 5 conditions recommended by staff.
Thank you.
That's my motion.
Thank you, sir. Do I have a second? Second. Thank you, sir. We have a motion that's been properly moved and second. Any discussion? All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. So you're 2 for 2 today. Next time, let your daughter go ahead and do the presentation. Since you're getting so good at it, give her a whack at it once. But within 10 days, you'll be getting information from staff letting you know the next steps in the process. Congratulations, and you have a good night. It's good to see you. All right, the next case is BZA 03-26-00961. Mr. Hare will be presenting this case for us.
The applicant and property owner, Michael John Clemens, is requesting a special exception to establish a short-term rental property extended home rental at 2212 Seroy Street, TMS number 343-05-00009 on James Island in Charleston County. The subject property and adjacent parcels to the north, east, and northeast are located within the low-density residential R4 zoning district, while properties immediately to the south and the west fall under the jurisdiction of the city of Charleston. According to Charleston County records, the property contains a single-family residence constructed in 1948. The applicant proposes to operate the residence as an extended home rental by offering 3 bedrooms for short-term rental use, accommodating a maximum of 8 guests, and providing 6 on-site parking spaces in compliance with Charleston County Zoning and Land Development Regulations Ordinance (ZELDAR). The property owner has indicated that they will manage the rental operations themselves. The property is owner-occupied and therefore eligible for a limited home rental permit. The applicant previously held an LHR permit in 2022, 2023, and 2024. The applicant is now seeking a special exception to operate the property as an extended home rental. Here's a location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low-density residential zoning district. The 300-foot radius map. Aerials of the property. We posted on April 15th of 2026. Here are pictures of the single-family residence and its parking. Pictures of adjacent properties, Seroy Street, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3, and we did receive 1 public comment in support to this case. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the Board decides to approve the application, the Board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. And 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County Noise Ordinance. Is there any questions?
Any questions of staff? Thank you, Mr. Hare. Is the applicant present?
Yes, sir, right here.
Please come to the podium. Were you sworn in?
I'm sorry?
Were you sworn in?
No, sir, I was not.
Very good. Please come to the podium. Okay, Ms. Working. You have to stand, please.
I swear to tell the truth, nothing but the truth, I do.
As a group?
I do. Just say I do.
Just say I do. Thank you. All right, please state your name and address for the record, and please tell us why we should approve your application.
Yes, sir. My name is Michael Clemens, and my address is 2212 Seroy Street, Charleston, South Carolina. And aside from sitting through that first, that has nothing to do with mine. I've been spending a lot of time with my folks in Aiken. They're aging, and it just happens to be open on weekends. Makes sense to be able to have somebody use it. It's a very special property. It's 0.58 acres. It's up a gravel road. I really have no neighbors in the vicinity. Nobody would be inconvenienced by it. Again, it is my primary residence. I do work Monday through Friday here in Charleston, so be on weekends, and again, it's a massive lot. It's backed up by the Charleston Municipal Golf Course and up a gravel road with no through traffic. It would be in line with the character of other properties in the neighborhood. It's in Riverland Terrace on James Island, and I would appreciate your approval.
Okay. Let's see if we have any questions for you. Yes, sir, Mr. Jordan.
So where do you think you'll be on the weekends?
Aiken, South Carolina, sir.
So, so 4 o'clock in the morning, there's a complaint about that place. Who's going to come take care of it?
I suppose I could hire a on-call management company. I have a house on Folly Beach that I do use a management company for. I've got one on East Bay Street downtown that I use a management company for, and I've considered using them for this as well.
Well, I'm not trying to suggest you do that, but I'm just saying that's a frequent concern here. That,
Yes, sir.
Knowing human nature as it is, some people get drunk, some people get loud, who knows? And didn't you say there's some people that live somewhat around it?
Somewhat. There's only one other address on the street, but I'm in very good a good relationship with my neighbors.
Well, that's my question. That's what I'm leading to. They got a problem. Who are they going to take care of? You're not going to drive down from Aiken to take care of it. I assume. Who will?
I absolutely would if I needed to, sir. I don't foresee that.
Short term.
I haven't specifically reached out to anybody to designate a manager. I can do that if I need to, though. I mean, I have a good relationship with the management company already that manages other properties.
Thank you.
Yes, sir.
So how are you going to advertise it? What vehicle and platform are you going to use to advertise this?
Just Airbnb and VRBO.
Okay. And you've had experience using those platforms?
Yes, sir, for many years. I used to live on Folly Beach, and I bought this actually as an investment property back in 2018, and it's a huge lot. I thought I might subdivide it, and the more time I spent there, I fell in love with it. I've got 2 dogs. I love to play golf, and just decided it was a better setting for me and my dogs. So we decided to move in and call it our primary residence, and we love it. The Riverland Terrace neighborhood is a great community, and we like being a part of it.
Okay. Yes, sir. Down here. I'll come back.
Yeah, just looking at the aerial, that backs up to number 12 on municipal.
Yes, sir.
Yeah. So it's 3 bedrooms. I mean, I think what my colleague was saying is management company really helps because it limits problems. If you're dealing with parents, I'm dealing with my 98-year-old dad, and he lives here locally. So
Yes,
management companies I can strongly recommend to use. You don't want to be dealing with all the little issues that are going to be out going on and stuff like that. It'll make things easier so that when you have to renew your permit and you have had noise violations, things like that. So I'd strongly recommend to go ahead and, or at least say that you're going to get that done. It probably
Yes,
helps
sir.
you.
I've certainly considered it, and I've actually had them out to the property, and they've given me an estimate that, could wrap it under the umbrella of the other ones.
Right.
That's
Thank
certainly
you.
something I'm looking into.
Thank you. You're getting an unusual amount of questions on this one, but I just want to reiterate, you had an LHR permit 22, 23, and 24 for this property, right? And
Yes, sir.
You rented it out, 70 days a year at that time,
Less than
correct?
the required amount, or than the allowable amount.
So in short, you have a lot of experience renting this particular property, correct?
Somewhat, yes, sir.
Okay.
For
All right, thanks.
a number of years, yes, sir.
Good question.
Okay. Anyone else?
I just want to check off the boxes, and I'm often concerned, especially where I live, about environmental impact, and that are you on septic or are you on sewer? If you're on sewer, I don't need to go any further.
I'm on sewer.
You're on sewer? Okay.
Yes, sir.
Okay. And second thing, what do you do about bringing the trash cans in? Who's going to take care of that?
It's the same as this gentleman mentioned earlier. It is posted in the rules that, what trash pickup day is. So you hope the guests do it, but I'm home every Monday morning, and the trash comes on Monday morning.
Okay.
I took it out.
There's services that are available to do that. But the problem I see quite often where I live is they leave on Sunday, the trash is picked up on Tuesday. If they take it out when they leave on Sunday, dogs, raccoons, possums, whatever, get into it, knock it over, and trash is all over the street. or trash is emptied and the trash can remains in the street and people drive over it. And
Yes,
you
sir.
can imagine, how are you going to take care of those kind of problems?
Well, fortunately, we have zero through traffic, so nobody's going to drive over it. And again, it's a gravel road. There's only one other house on the street, but I've been taking it out myself for 7 years, and
Okay.
nothing's really going to change with the way that I'm currently living there. I just got an Aiken on some weekends, and I'm back on Sunday night, just like last night. And
But you can make arrangements so that.
I can absolutely make arrangements. Yes,
All right.
sir. It's a great neighborhood, and all the neighbors help each other out as needed, but I don't foresee that being an issue. But I will arrange for it if it ever does become one.
All right, thank you.
Yes, sir.
Anyone else with a question? Thank you so very much for your testimony.
Thank you guys for your time. Thank you.
Yes, sir. Do we have anyone else to speak in support? Do we have anyone to speak in support? Do we have anyone to speak in opposition? Very good. The case is closed to the public. Board members, do we have any questions of staff? Do we have any general discussion?
Mr. Chair, there was a letter of support that existed, if I recall.
Yes, sir.
All right.
That's who'll take my trash out.
That's what that was the point I was going to. Thank you. Yep.
That's hilarious. At this time, I'd like to entertain a motion to either approve or deny this case. Ms. Smith?
I'll make a motion in the case of BZA 0326000961 to approve the special exception to request to establish a short-term rental property on the basis that it complies with criteria 1 through 3 of the special exception approval criteria for short-term rental properties. It's compatible with the existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. Adequate provision is made for items such as setbacks, buffering. It has fences, landscaping to protect adjacent properties from the possible adverse influence of the proposed STRP use. It complies with all applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, and applicable STRP site plan review requirements of this ordinance. I'd like to include the 4 staff recommendations with this special exception, with this motion.
Very good. Can I have a second? All right. We have a motion that's been properly moved and second. Any discussion? All those in favor, please indicate by saying aye and raising your right hand. Aye. It is unanimous. So your application has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Congratulations and good night, sir.
Thank you. I really appreciate it.
You're welcome, sir.
Yeah. Yes, sir.
Okay, next case, BZA 0326000962.
All right. The applicant and property owner, Jessica Garner of JBT Southern Rentals LLC, is requesting a special exception to establish a short-term rental property, extended home rental at 156 Grimble Avenue, TMS number 343-0300171 on James Island in Charleston County. The subject property and adjacent parcels are located within the low-density residential R4 zoning district. According to Charleston County records, the property contains a single-family residence constructed in 1991. The applicant proposes to operate the residence as an extended home rental by offering 1 bedroom for short-term rental use, accommodating a maximum of 2 guests, and providing 3 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance, ZELDAR. The property owner has indicated that they will manage the rental operations themselves. The applicant previously did hold a limited home rental permit in 2020 and in 2021. The property owner continues to live on site. However, the property no longer receives the 4% legal residency tax assessment ratio. Because the property is no longer considered owner-occupied for assessment purposes, it does not qualify as a limited home rental. The request must therefore be reviewed as an extended home rental in accordance with ZELDAR requirements. This is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low-density residential zoning district. The 300-foot radius map, aerials of the property. We posted on April 15th of 2026. Here are pictures of the subject property, single-family residence and its parking. Pictures of adjacent properties, Grimble Avenue, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3, and we did receive 1 public comment in opposition to this case. Also, just a little bit of background for 156 Grimble Avenue. Staff's research using Rentalscape software showed that the property had been rented illegally last year for more than 72 days, but fewer than 144 days prior to issuance of the NOV. The property owner cooperated by removing the listing and ceasing all rental activity immediately upon receipt of the notice. If the BZA approves this request, the property owner can obtain all required permits and resume renting the property legally. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the Board decides to approve the application, the Board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, prior to the issuance of the STRP zoning permit, the applicant must obtain all necessary approvals and permits from building and zoning departments. Is there any questions?
Any questions of staff?
I have one question. Cole, how long did this was this property illegally operated?
As far as I can see, it was just last year. I can try to go back and look a little bit. But like I said, they did have a permit in 2020 and 2021. It just was never renewed after that. And then we found it last year. So
sometimes these things just drop off the radar screen.
Yeah.
Okay. Anyone else? You're still working on that, I know.
Yeah.
So, all right. Is the applicant available? Is the applicant here? Present. Please state your name and address for the record, and please tell us why we should.
Susan Garner.
If you would talk into the mic, Ms. Gardner, I appreciate it.
I'm
Just move the mic, if you would, so we can hear you. There you.
Susan Garner.
All right.
Okay.
Thank you, Ms. Gardner. And
I'm
your
from-
address?
I live in Lynchburg, Virginia. My daughter lives on the property.
So if you would slide over just in front of that mic. There you go.
There you go. Talk right into the microphone.
Okay.
Some of us have hearing aids, and we want to hear every word you say, okay?
That's me.
So my daughter lives in the property and rents out, the short-term rental.
And
Well, all I have to say is last year we operate a LLC, and I get the mailings in Virginia, but she lives down here, and that was part of the problem in it not getting renewed. I went on vacation or something, so she didn't get it.
okay, so she's living.
She lives in the house.
She lives in the house.
Right.
Is she here today?
No, she's out of town, which is why I came.
And you live where again?
I live in Virginia.
And you came all the way down to see us today.
I come down, quarterly.
Wonderful.
I'm a big part of, running the house. So, yeah.
So I know we're going to have some questions for you, Ms. Gardner. I'm going to start on my right.
Okay.
Thank you. So are you who operates the house? Obviously, you own it with your daughter, it sounds like.
Right.
Who runs it? Do y'all have a management company?
No.
What's going on?
No. Well, she lives there. She manages it. I live in Virginia. I pay most of the bills.
And why isn't she here tonight?
She's doing a training course. She's in Costa Rica right now. So.
Okay, is she coming back anytime soon?
Yes, yes. I'm here while she's gone, and then I'll leave and she comes back.
Is there something we're reviewing the application tonight, but usually we hear from the owners that are involved in it. Is there something you would consider deferring until she came back or something? Or do you feel comfortable with answering all the questions about the house?
I'll answer any questions, yeah.
I'm
pretty
kind of
familiar.
concerned.
I took trash out this morning. I know what days they come. I know what color brown on Monday.
I'm just
blue on
concerned about
Wednesday.
how
Yeah.
it was operating illegally and why we should let it now operate legally.
Well,
And
that's, I think that's probably my fault, because I get a lot of the mail in Lynchburg. I pay insurance, all those bills, and it came there, and I overlooked it. I didn't put the form in.
And you don't have a management company that monitors anything?
No, we've been doing it for a lot of years.
Yeah, sounds like it. All right, thank you very much.
Mr. Jordan, you had a question? Yes, sir.
No, I was just going to make a comment, but I was satisfied that this was just what I would call an oversight. You live in Virginia. I understand how sometimes when you have a corporation, things don't always get there.
Right.
You've made every effort to make it right, and it's only been 1 year. It's not like you have a history of
No.
avoiding the law. So,
Well, she's been, she's the
and your
super-
daughter's here.
Huh?
And your daughter is here.
She lives here. She lives in the house.
Yes, ma'am.
Yeah,
I got it.
yeah. She's been a super host. She does a great job. I don't feel like I need to hire anyone else.
I got it.
Anyone else on my left? Go ahead, Mr. Jordan.
Do you expect your daughter to remain staying there extended time?
Well, yes, probably.
I was just curious.
She has given me no indication she's going to get married and move out, nothing, I think she's pretty permanently settled.
Okay, thank you.
She's been there, 10 years, so.
So your guest will be staying in the ADU?
ADU.
Mother-in-law suite.
Oh, yeah, it's a one-bedroom apartment.
Okay. All right, thank you, Ms. Gardner.
Mhm.
Do we have anyone else to speak in? Yes, sir. You must be Mr. Gardner.
I live my name is Glenn Sullivan. I live at 1313 Trent Ferry Road, Lynchburg, Virginia, with Susan. And we have a farm there, horse ranch. And I can attest to Jessica's expert ability in terms of property care and keeping the property up. And she takes great pride in having a good experience for tenants that stay there. She's actually been doing this for 10 years, long-term rental, not short-term rental. And then she switched over to short-term rental more recently, But she's proud of her area. It's a great area. It's a beautiful area to walk down at night, during the day, trees, and they're just gorgeous. This is a beautiful place, and it's a very active place. Jessica she taught me how to do some of the Airbnb procedures. I have 6 houses that I own and manage in Lynchburg and do all the repairs on, for my own properties. So I have some experience in that, and I, support Susan and, having this one Airbnb VRBO property here in Charleston. It's a great, people love it to stay there. We have friends that come and they rent the Airbnb. She's a super host. She's very artistic, has a lot of pamphlets and, it's kind of a book that you have for an Airbnb. All the places you can go to, the restaurants, the enormous amount of restaurants here. It's a good experience for tenants, guests to stay at, and it's worked out very well. So that's about all I have to say.
Okay.
Any questions?
Thank you for that. Do we have any questions on my left? Thank you so very much.
You're very welcome.
Do we have anyone else to speak in support? Do we have anyone to speak in opposition? Thank you. Case I'm sorry. I apologize. So you're speaking in opposition?
I am.
Okay.
And I learned some things tonight. My name is Joan Generakis. I own 2026 Frampton Avenue.
What was the avenue again?
Frampton.
Frampton, yes. Okay.
Grimble's here, Frampton's here.
Yes, ma'am.
I'm
I just
on the-
didn't hear you.
I'm on the corner.
Okay.
So three houses this way, I've got a Airbnb. 3 houses that way, I have an Airbnb. I have people walking up and down the street. When I walk my dog, I don't know who these people are. I bought the house because I want to live there in a neighborhood, not in a hotel where people are coming and going all the time. I just learned that this has been maybe operating as a short-term rental for a while. Haven't known, but it's enough is enough. I'm really tired of having strangers in my neighborhood. So that's my opposition, and probably won't matter. But I think that Riverland Terrace is a great place, and when I walk my dog, I like to know who my neighbors are versus who's there for the weekend for the week. Thanks for hearing me.
Okay, well, I will say this. Your opinion matters to me. So, and I know it matters to the rest of our board members too. But you said something interesting. You have an Airbnb, you said? Or
do I have it? No, I do not have it.
Okay.
No, there's three houses down that way and 3 houses down. There's one right across the street from the applicant. There's an Airbnb.
So you have a lot in your
I've
neighborhood.
already got 2 within a six house radius.
Okay, so did you ever have to call the cops?
I have not.
Okay. You ever had a problem with noise or anything like that? Loud noise at parties?
I haven't called the cops. There's been parties.
Okay. You have
At-
a lot of
at
loud
one of them.
noise?
Not a lot of loud noise, but there are.
Coming from the
there are-
Airbnb, that is.
From the Airbnb, on one of them, yes, there has been noise that has, they're partying. That's okay. It's not all the time.
How long ago was that?
It was probably 4th of July or New Year's. New Year's. It was New Year's.
Well, you would expect it on New Year's.
Well,
so-
yeah, that's why. I mean, not a big deal. There are other times that they get a little rowdy, but it's not horrible.
I thought one
But
heck
I
of a
don't
party
want.
on
I don't want the
New
whole
Year's myself.
neighborhood. Okay. Well, I'll just rent out 5 rooms in my house. You know what I mean? It's not. I want to know my neighbors, and it's difficult when you're walking down the street and you don't know who these people are, and they're going to the Airbnb, and whatever.
Okay. So I like that you are very involved in your neighborhood. You know the majority of people in your subdivision?
I try to know my immediate area. Yeah.
That's awesome. Mr. Jordan has a question for you.
How do you know? So this particular location, this address, have you had any complaints or problems with them?
No.
Thank you.
Not directly.
Okay. Anyone else? I thank you so very much for your testimony today.
You're welcome. Thank you.
Yes, ma'am. All right. Good luck. Anyone else to speak in opposition? Very good. This case is, you have the right for rebuttal if you care to rebut. Okay, no rebuttal. Very good. The case is closed to the public. Board members, do we have any questions of staff? We have any general discussion?
I was going to say, Mr. Chairman, I share the concerns of the lady who opposed, but I've watched my neighborhood go from 0 short-term rentals to now 70%, and most of them are very, very good. Some of them are bad, but you often would be better with once in a while having somebody that might not be so good than having somebody bad there the whole year. And if it makes you feel any better, these folks have a very, very high rating for their experience, 4.9 out of 5.
I didn't know that they had it before.
All right. Okay. I hope that makes you feel better. And we're not a rubber stamp. We look at each one of these. But I get it, and I worry about.
Okay, can I get a motion?
Yes, sir.
Okay.
I'll make a motion, or if
Thank you.
you'd like. Mr. Chair, in case 03-26-00962, I move that we approve the application for a short-term rental in this case. The requirements are set forth in Zelda Chapter 6. Criteria specifically are in 6.8, 2C 1 through 3. All the criteria have been met. It appears that one of the attractive things about this is the daughter of the owner actually resides on the property. They've got a very high rating for experience for people that are there. It's obvious that the property is well taken care of, and it's ironic, but often, almost always, the short-term rentals are better cared for than longer-term rentals. I do worry about, housing for working folks and affordable housing, but that's not before us, and our hands are tied. The conditions that are required and the criteria have clearly been met. There's been a very thorough examination by staff. They've reviewed this. We're talking about a one-bedroom with a maximum of 2 guests. This is compatible with the existing uses in the vicinity. I understand that there are other short-term rentals there, so this won't. I would find and conclude that the community, the area, the vicinity is not adversely affected. The adequate provision, number 2, has been made for things like setbacks, buffering, for parking. I mean, even though this is a very modest property. Number 3, it complies with applicable. It has or will now, going forward, comply with applicable rules, regulations, laws, and standards. I make this motion subject to the 5 conditions recommended by staff.
Thank you, sir. Thank you, sir. We have a motion that's been properly moved and second. Any discussion? All those in favor, please indicate by saying aye and raise your right hand. 1, 2, 3, 4. It is unanimous. Carries. So, Ms. Gardner, your daughter's application has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Congratulations, and you have a good night. All righty.
4 more.
My pork chops and my mashed potatoes and gravy are getting cold. I've just seen a picture.
It's not fair that you're discussing meals right now.
Next case, BZA 0326000963.
The applicant and property owner, J. Morris Porter of 1943 Culver LLC, is requesting a special exception to establish a short-term rental property, extended home rental, at 1943 Culver Avenue, TMS number 350-1300115 in the St. Andrews area of Charleston County. The subject property and adjacent parcels to the north, east, south, and west are located within the low-density residential R4 zoning district, while adjacent parcels to the northeast and northwest fall under the jurisdiction of City of Charleston. According to Charleston County records, the property contains a single-family residence constructed in 1965 with 3 bedrooms. The applicant proposes to operate the residence as an extended home rental by offering all 3 bedrooms for short-term rental use, accommodating a maximum of 8 guests, and providing 6 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance, ZELDAR. As you'll see in the table, bedrooms 1, 2, and 3 will have a maximum of 2 guests, and there will be a den area as well, allowing for 2 guests, totaling 8 guests. The property owner has indicated that they will manage rental operations themselves. The applicant previously held a limited home rental LHR permit in 2024 and 2025. However, since the property is no longer owner occupied, it does not qualify as a limited home rental, and it must be reviewed as an extended home rental in accordance with ZELDAR requirements. Here's a location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low density residential zoning district, the 300-foot radius map, the aerials of the property. We posted on April 15th of 2026. Here are pictures of the subject property, single-family residence, and its parking, pictures of adjacent properties, Culver Avenue, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, prior to the issuance of the STRP zoning permit, the applicant shall remove the non-grand tree located in the center of the front lawn in order to comply with the parking requirements. Is there any questions?
I have a question to start off with. The 4 parking spots, they're in the front side back, but you also mentioned that they're trying to get the tree removed so they can park in the rear, right?
Yes, sir. They were having some right-of-way, as you see in that. The tree's in the front. So
Trees in front,
it's
yeah.
these 4 spaces that they have here. The tree is located literally in the center. So in order for it to make functional sense, we required them that they remove that tree before issuance of the permit if granted approval. So the parking plan makes sense.
But they can park in the setback. It doesn't matter.
No, that's within the property boundary line, so they're good.
But it's in the setback, right?
That's
We allow parking.
Okay.
Sorry, I think the right of way they're inside the right of way, so they're good.
Okay.
But the setback,
Okay.
yes, we allow parking in the setback.
That's
yeah.
right.
Mr. Chair, is that a variant that they're going to be bringing a tree thing to us? Is that or is that something?
It's not a grant. It's not a grant tree. Grant tree.
Not a grant.
Yeah. Mm.
Okay. I'm sorry, I monopolized the time. Anyone else have a question? Okay. Thank you, Mr. Hare.
Yeah.
Is the applicant present? Please state your name and address for the record, and please tell us why we should approve your application, sir. There you go. A little bit higher. You don't have to bend over. It'll come up. Thank you.
My name's Morris Porter. I live at 10 Old English Drive in Charleston, 29407. The property is located at 1943 Culver Avenue. We're requesting a special exception to make it a extended home rental. My wife and I are going to self-manage. As he stated, it's been a limited in the past, so we've had experience managing it, advertising, doing everything that goes along with it. So we're ready to keep it going and here to answer any questions.
Mr. Jordan?
How close do you live to the property?
We're within, I'd say, 7 or 8 minutes, maybe 10 at the most.
And what part of Charleston is this community?
This is Air Harbor, St. Andrews.
Thank you.
And that was my question, literally. Yeah.
Any more questions?
I always ask, septic or sewer?
Sewer.
All right.
Thank you. Anyone else to speak in favor? No, you may have a seat, sir. Anyone else speak in favor? Anyone speak in opposition? Anyone speak in opposition? Closed to the public. Board members, do we have any questions of staff? And in general discussion? May I have a motion to either approve or deny this application?
Go ahead. You ready?
Okay, thank you, Ms. Smith.
In BZA 0326000963, I'd like to make a motion to approve the special exception request to establish a short-term rental on the basis that it meets the 3 exception criteria from section 6.8.2 of ZELDAR. 1, it is compatible with existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. 2, adequate provision is made for items such as setbacks, buffering, to protect adjacent properties from the possible adverse influence of the proposed STRP use. And 3, it complies with all applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use condition, zoning district standards, and applicable STRP site plan review requirements of this ordinance. I'd like to include the 5 recommendations from staff in this special exception
Okay,
request.
can I get a second? Okay, we have a motion that's been properly moved and second. Any discussion? All those in favor, please indicate by saying aye. Aye. Any opposed? Very good. Your application has been approved, sir. Within 10 days, you'll be getting information from staff, letting you know the next steps in the process. I hope that both of you have a safe drive home. Good night. And cut the tree down. All right. So our next case, BZA 0326000964, will be done by Mr. Hare.
All right. The applicant and property owner, Richard E. Stoughton, is requesting a special exception to establish a short-term rental property, extended home rental at 1933 Culver Avenue, TMS number 350-1300119 in the St. Andrews area of Charleston County. The subject property and adjacent parcels to the south and the west are located within the low-density residential R4 zoning district, while adjacent parcels to the north and east fall under the jurisdiction of City of Charleston. According to Charleston County records, the property contains a single-family residence constructed in 1959 with 3 bedrooms. The applicant proposes to operate the residence as an extended home rental by offering all 3 bedrooms for short-term rental use, accommodating a maximum of 10 guests, and providing 5 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance ZELDAR. The 1 parking space located within the garage will remain clear and available for use by the STRP guest. The property owner has indicated that they will manage the rental operations themselves. And the property is owner occupied. The owner has previously obtained limited home rental LHR permits in 2025 and 2026. LHR permits allow for up to 72 days per calendar year in aggregate. The owner is now requesting an extended home rental EHR permit in accordance with ZELDAR requirements. You'll see as well in the table that the bedrooms 1, 2 will allow for up to 2 maximum guests, and bedroom 3 will allow 4 maximum guests. And then the living room will have a sleeper sofa for a maximum of 2 guests, totaling 10 guests. Here is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low density residential zoning district, the 300-foot radius map, aerials of the property. We posted on April 15th of 2026. Here are pictures of the single-family residence and its parking, pictures of adjacent properties, Culver Avenue, the site plan, tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3, and we did receive 1 public comment in opposition to this case. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. And 5, the 1 parking space located within the garage shall remain clear and available for use by the STRP guest. Is there any questions?
Yes, sir.
Mr. Hare. Thank you again for the presentation. I probably should ask this on the last presentation, but when a property is going from an LHR to an EHR, does the LHR have to show the same parking requirements?
Yes, sir.
Okay. All right. Thanks.
Yes, sir.
Has there been any noise violations or any type of violations on the property going where it was LHR? Or?
No, sir. They got their LHR in 2025, I believe, later in that year. Sorry, to go back to your question, if the bedrooms are different, if there's a different number of bedrooms, that would change the parking requirements. So.
And they have an ADU of 408 square feet, right?
No, sir. They did have structures last year in the past, but they got the required demo permits. I believe those are all been demoed. And they got those permits before we issued the zoning permit last year for the LHR. Okay. So there's no ADU or accessory. It's just a single family.
Okay.
10 people.
Thank you. We all
I'm having
good?
a hard, excuse me, I was
Yes,
gonna ask- I'm having a hard time with the parking issue. I mean, aside from 10 people in a I think it's 3-bedroom house.
Yes.
That sounds like if they're on sewer, they're going to be able to handle it. If they're on septic, they're not. But can you explain to me the parking?
Yeah, so it's required 2 parking spaces for the dwelling unit itself, and then an additional parking space per bedroom. So they actually only needed to show 5. It might have been a little confusing because the previous, but yeah, they only needed to show 5 parking spaces total.
Mr. Chair, may I follow up on that question? Because I think the issues that we're seeing a lot lately, although every application is different, is owners are turning the living rooms into bedrooms. And we should be more clear on how many, or at least ask questions more clearly on how many parking spots are needed, because they're trying to maximize, and I get it, they're trying to get as much money as they can for the stuff, but when they come in for a 3-bedroom house should be for 6 people, maybe 7 with child. But when it comes to 10, they're really having a 4-bedroom house, they're just relabeling the living room as a bedroom. So that's just something to think about. But that's something I'm going to ask the applicant in a minute. But maybe down the road we should be thinking.
Yeah, it's not something right now that we get into the specifics on
the
the
ordinance
bedroom.
is the ordinance, but it's just that's how the ordinance is getting stretched. Is they're not calling it a bedroom, they're calling it a living room, and they're putting a sleeper sofa in there. What's to keep them from putting bunk beds in the living room? So just something to think about. Thank you.
Is the applicant present? Please state your name and address for the record, and please tell us why we should approve your application.
My name's
sir.
Richard Stoughton. I live at 5 Lambton Road, which is about a mile away from the 1933 Culver. We've lived there for 20 years. My father purchased it. I operated and managed it as a rental long term. And then I got married and we raised our kids there, and we want to keep the house and maintain it. And we think short-term rental is the most effective way to not let the house go bad. We can keep up with problems. They arise faster. So that's where we're kind of headed in this direction.
Won't you address the question about the living room for us?
So we were thinking we only advertise it for 9 people. 10 was just the permit. And we're kind of targeting like 2 families. So the living room's a sleeper sofa, and then we have the 1 bedroom is 4, it's got bunk beds and a queen, and then the other 2 bedrooms have queens.
So that living room is basically, it has its own bathroom, I see. I'm helping you, okay? I'm asking you a question. That living room that's off the garage has a bathroom?
Yes, sir.
Okay. But it also has access to the garage. Is that still accurate and correct?
Yes, sir. And it is up to date. It is permitted because I got a stop work order because I didn't know you had to have a permit. So it is permitted.
Okay.
Did I hear you correctly? Is the garage open? If it's not going to be used for storage?
Oh, no, sir. I sent Cole a picture of the garage because I came to an April meeting, and I emailed it to him, and that was your concern. So I wanted it attached to the
homework.
Thank you.
And I love taking the trash out. It's not a problem. I do it at my house every week. I'll do it at that house. And at 4 a.m., sleep's a nicety, not a necessity. I'll be there to take care of any problems that arise.
Got my vote.
Mr. Chair, can I ask? Oh,
No. I'm going to get in for this. So you came and you scoped us out so you can kind of figure out what to do and what to say?
A little bit. I've never been through one of these before. I didn't know what to expect.
That's good. That's
Yeah.
No, that's good. I'm
good.
kind of tickled to hear that. Go ahead.
Would you be fine with reducing it to 8 or 9 or something?
Well,
10.
we advertise 9.
I know, but the application says 10. So
I'd be fine with 9.
yeah, if we made it a condition of the approval to maximize at 9 instead, it's just when you start having 10 people, like I said, you're basically turning a living room into a bedroom.
Yeah.
And by doing that, you don't have to have the parking.
So I'm a charter captain by trade, and I commercial fish. And we ended up just purchasing a new boat that takes up to 14 passengers just for the fact that a lot of families want to come together. So you have 4 adults and 6 kids. They each have 3 kids. I mean, 10 is kind of the number. And that was what we were kind of targeting.
Then you're turning your living room into a bedroom. So then you would have to have an extra, which is no problem, but then by having an extra bedroom, you have to have more parking. And then
Yeah.
the parking requirements are changing. We're saying people are getting
I mean,
around
but the kids
it.
aren't driving.
Huh?
We're not letting the kids drive.
I'm just asking you a simple question. Do you want to make it at 9 or do you want to keep the application weighted at 10? It's very simple.
I'd like to keep it at 10, just
Okay,
for the
that's
just
fine.
for the fact. Yes,
No
sir.
problem. Thank you, Mr. Chair.
Any other? Yes, sir.
Under your existing LHR permit, have you had any issues related to
No, sir.
rentals or anything? All right, thank you.
Not that we've known of. I mean, and we go by there. I mean, there was a plumbing leak, and we found it before the people even reported it. Fixed it today.
And that it allows 10 underneath the current application?
I don't. Is it 10, Cole?
So, ma'am, if you would just not refrain from speaking, that's okay. What were you saying, sir?
Yes, it is 10.
Okay. All right, thanks.
And like I said, we have it capped at 9. I mean, just the permit.
Anyone else have a question? You didn't have a question?
No, sir.
Okay. All right. Thank you so very much for your
Yes, sir.
testimony.
Thank y'all.
Yes, sir. Does anyone else want to speak in favor of this application? We have anyone to speak in opposition? Very good. Case closed to the public. Board members, do we have any questions of staff? Any general discussion? I'd like to have a motion to approve or deny, please, with this case.
Mr. Chair, in the matter of BZA 0326000964, this application for a special exception for an extended home rental, I would make a motion to approve this request that, one, it is compatible with the existing uses in the vicinity and will not adversely affect the general welfare or character of the immediate community. The fact that the applicant has been operating a limited home rental at this location for a couple of years really is evidence to their ability to continue to do so with some additional nights. That, two, there are adequate provisions have been made for such items as setbacks and buffering and possible adverse influence from the STRP use. I did not ask the question, but I believe we would know if there were some significant disturbances to the neighbors, and we don't have any reports of that, so I would say we meet that criterion. And that, three, it complies with all applicable rules, regulations, laws, and standards of this ordinance. And the applicant is here to make sure that they have the proper permits to operate, so I believe we meet that criterion. In making this motion, I would include all 5 of the special conditions recommended by staff.
Very good. Do I have a second?
Second.
Okay, we have a motion that's been seconded. Any discussion? All those in favor, please indicate by saying aye and raise your right hand. Aye. 1, 2, 3, 4. Any opposed? It carries. Congratulations, sir and ma'am. Your application has been approved. Within 10 days, you'll be getting information from our staff letting you know the next steps in the process. Congratulations. Thank you.
We'll be here next month. Feel free to come on back and watch again.
Mr. Ray, please, can we get a show of hands who are actually approved? I'm sorry, I'm congested now.
I think
It was unanimous.
Unanimous.
Okay, thank you.
My iPad is almost done and it went out.
Just talk faster.
Please. So our next case is BZA 0326 0065, and Mr. Hare will be doing it again. 65.
965, yeah.
Oh, my camera works.
The applicant and property owner, Krista Crawford, is requesting a special exception to establish a short-term rental property, extended home rental at 1334 Vine Street, TMS number 41805000055 in the St. Andrews area of Charleston County. The subject property and adjacent parcels to the east and the west are located within the low-density residential R4 zoning district, while adjacent parcels to the north and the south fall under the jurisdiction of City of Charleston. According to Charleston County records, the property contains a single-family residence constructed in 1960 with 3 bedrooms. The applicant proposes to operate the residence as an extended home rental by offering all 3 bedrooms for short-term rental use, accommodating a maximum of 6 guests, and providing 5 on-site parking spaces in compliance with the Charleston County Zoning and Land Development Regulations Ordinance, ZELDAR. As you'll see in the table below, bedrooms 1, 2, and 3 will just have a maximum of 2 guests staying in there, totaling 6. The property owner has indicated that they will manage the rental operations themselves. The applicant previously held an LHR permit in 2023, 2024, and 2025. Since the property is no longer owner-occupied, it does not qualify as a limited home rental, and it must be reviewed as an extended home rental in accordance with ZELDAR requirements. This is just a little bit of background as well on this property. For Vine Street, staff's research using Rentalscape software showed that the property had been rented for more than 72 days prior to the issuance of the notice of violation. The LHR permit allows for up to 72 days in aggregate per calendar year. The property owner cooperated by ceasing all rental activity immediately upon receipt of notice. And if the BZA approves this request, the property owner can obtain all required permits, resume renting the property legally, and the violation hold would be lifted. This is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low density residential zoning district. It's the 300-foot radius map. Aerials of the property. We posted on April 15th of 2026. Here are pictures of the single-family residence and its parking, adjacent parcels, Vine Street, the site plan, the tenant notice, and the plat. Regarding the 3 approval criteria, staff stated that that they made criteria 1 through 3. It may meet criteria 1 through 3. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the board decides to approve the application, the board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, the use shall comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. And 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. Is there any questions?
Any questions? Yes, sir.
I was just going to ask the same questions I've asked before. Do you know how long the applicant was in violation of the law?
So I was only here last year, so they had the permit. They were just over the amount of days, so they also received a violation. So it was only for last year. So
that answers it. Okay,
yes, sir.
Thank you.
I noticed also, Mr. Harris, that this diagram does not have any dimensions on how big these bedrooms are.
Yeah, for a tenant notice, we don't necessarily require that it have dimensions. We just need to see somewhat of a floor plan. It's not required in our ordinance that it's be like an architectural drawing of a floor plan. So,
thank you, Mr. Hare.
Yes, sir.
Is the applicant present? If you would, please state your name and address for the record, and please tell us why we should approve your application.
My name is Krista Crawford. I currently reside at 1544 Roustabout Way in West Ashley. I am about 20 minutes from my current property, from the rental now, so I can reach it at any time. I own this house for about 20 years. I bought it in my 30s when I was a single female. I had my daughter in this house. I raised her until she's now 14. It means a lot to me. I'd like to keep it forever, which is why I went this route to hopefully supplement the mortgage. I have rented it for 3 years. I have been a super host for 3 years. I 100% went over my days. I hold myself accountable to that. It will not happen again. I am on a sewage line, and my husband works at MUSC, so he passes the house almost every single day. Trash is not an issue. If the guests don't do it, we take care of it. What other questions have you all asked?
Thanks to you, we have none.
Just trying to be prepared. Do you have any other questions?
No, I guess not.
Nope.
I guess that's how to shut us up. Thank you for your testimony.
Of course.
Oh, we only got one person. You're not going to... or
Last one.
Yeah, you the last one? All right. I had to say it. Anybody else? Support? Anybody else in opposition? Case closed to the public. Board members, do you have any questions of staff? General discussion? Someone please give me a motion to approve or deny. Anyone?
I'll practice.
You practice.
All right. In the case of BZA 0326000965, I'd like to make a motion to approve their special exception request to establish a short-term rental property. Sorry. On the basis that it meets the 3 special exception criteria from 6.8 of Zeldar. It's compatible with the existing uses in the vicinity and will not adversely affect the general welfare or character of the community. Adequate provision is made or exists for such items as setbacks, buffering, including fences and or landscaping to protect the adjacent properties from possible adverse influence of the proposed STRP use. She's got a lot of experience as an Airbnb host and knows how to deal with any sort of noise complaints or anything like that, and will be close by and able to drive by to address any trash issues. It complies with all applicable rules, regulations, laws, and standards of this ordinance, including but not limited to any use conditions, zoning district standards, and applicable STRP site plan review requirements of this ordinance. I'd like to include in this motion the 4 staff recommendations.
Thank you. May I have a second? Second. All right, Mr. Jordan. Any discussion? Questions of staff? All those in favor, please indicate by saying aye. Raise your right hand. Aye. Aye. It is unanimous. Okay, congratulations. Within 10 days, you will be getting information from staff letting you know the next steps in the process. Congratulations. You have a good night. You heard that. Okay, thank you. All right, Mr. Hare, our last case for the night.
Okay. He's not leaving.
BZA 0326000966.
All right. The applicant and property owner, Michael Wade Allen Jr., is requesting a special exception to establish a short-term rental property extended home rental at 946 Pine Hollow Road, TMS number 535-00000092 in the east area of Charleston County. Subject property and the adjacent parcel to the east are located within the low-density residential R4 zoning district, while adjacent parcels to the north, south, and west fall under the jurisdiction of the town of Mount Pleasant. According to Charleston County records, the property contains a single-family residence, 944 Pine Hollow Road, constructed in 1980, as well as a one-bedroom detached accessory dwelling unit located at 946 Pine Hollow Road, with permits finalized in January of 2026. The applicant proposes to operate the one-bedroom ADU as an extended home rental for short-term rental use, accommodating a maximum of 4 guests and providing 5 on-site parking spaces for the ADU in compliance with the Charleston County Zoning and Land Development Regulations Ordinance, ZELDAR. The property owner has indicated that they will manage the rental operations themselves. If you look at the table below, they are proposing the bedroom for a maximum of 2 guests, and the living room will have a sleeper sofa for 2 guests as well, totaling 4. The property is owner occupied, and the property owners reside in the single-family residence and are therefore eligible for a limited home rental permit. The applicant currently holds an active LHR permit for 2026 to rent the ADU. The applicant is now seeking a special exception to operate the ADU as an extended home rental. This is the location of the property when looking at the county as a whole. This is the zoning ordinance section pertaining to STRs in the R4 low-density residential zoning district, 300-foot radius map, aerials of the property. We posted on April 15th of 2026. Here are pictures of the single-family residence on the left and the accessory dwelling unit on the right. Here are pictures of the parking available, adjacent properties, Pine Hollow Road, site plan, the tenant notice, and the plat. little bit of background as well for 946 Pine Hollow Road. Staff's research using Rentalscape showed that the property had been rented illegally prior to issuance of the notice of violation for more than 72 days, but fewer than 144. The property owner cooperated by removing the listing and ceasing all rental activity immediately upon receipt of notice. If the BZA approves this request, the property owner can obtain all required permits, resuming renting the property legally, and the violation hold can be lifted. And then regarding the 3 approval criteria, staff stated that it may meet criteria 1 through 3. We did receive 2 public comments in opposition to this case and 1 public comment in support of the case. The Board of Zoning Appeals may approve with conditions, or deny case based on the BZA's findings of fact unless additional information is deemed necessary to make an informed decision. In the event that the Board decides to approve the application, the Board should consider the following conditions recommended by staff. 1, prior to the zoning permit approval, the applicant shall complete the STRP limited site plan review process. 2, that the use should comply with all requirements of Article 6.8. 3, the property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. And 4, the property owner shall be responsible for ensuring that tenants comply with the Charleston County noise ordinance. Is there any questions?
Any questions of staff? Thank you, Mr. Hare. If you would, please come forward, sir. You don't want one left in the room. Please state your name and address for the record for us, please.
My name is Michael Allen. I'm at 944 Pine Hollow Road, Mount Pleasant. Thank you all for hearing me today. I know I'm between y'all and dinner, and so I'll try and keep this quick. I've worked with Mr. Hare to get this process sorted. I'm going to take one of Mr. Truslow's sayings from his original first hearing. Sunshine's the biggest disinfectant, and that I was using it because reason we didn't get permits until 2026 was we had a building permit issue. I worked with Hakeem Boyd, Carter McMillan over there. We got all that sorted away, but when we did this, we had quite a few kids, and we still have we have 4 young kids in daycare. So candidly, like I said, Sunshine needed the money to help cover some daycare costs. So that's why we were doing that. But as soon as Mr. Hare got involved and was able to help guide the process, we got it taken care of properly. We do have a limited home rental permit active and in full compliance. So that's what we're asking for today, to address some of the key things. Myself, my wife, and our 4 kids and our dog, we all live on the property. We all have our own designated area. It's completely fenced. If you look on the site plan, the fence is actually mobile if we ever did want to move it, but we designed it that way. They have their own designated parking, designated access. We cross them in the driveway periodically, but they keep themselves. We live on the property, so trash is not an issue. We are on sewer, and we actually only advertise up to 3 people. We do have exceptions for like kids as a family with a bunch of kids, but we do have 4. A couple other quick comments. The neighbors all support us. We are very friendly with our street. There was 2 comments in opposition from a neighbor diagonal from us. I spoke with them. They were misunderstanding on what the actual permit or the request was for, and so after speaking with them, they withdrew or wanted to withdraw their comment. It was after the window had closed. I sent Mr. Hare and another BZA staff member an email with that owner copied this morning. I know he couldn't comment on that, but that was in the spirit of transparency. They withdrew their opposition to it. Our direct neighbor across the street is for it. Trying to think if there was any other issues. Parking, we could fit a fleet of vehicles on our driveway. It's very large, so there's not any issues with parking. I have been doing this for a long time now, even though only recently of record as far as y'all are concerned, but I have 97 reviews, 5 stars. I am a super host, so I know what I'm doing. I just am trying to go through the proper motions to get it done properly. So I appreciate you extending grace in that regard, and I hope that I'm happy to answer any questions that you may have.
So you've been doing it 5 years in violation?
Not that long. We haven't lived there that long. It's been maybe 2 years. 2-3 years.
2 years in violation?
Yes.
Okay. Tell me about this 900 square foot building? It looks like a garage. It was a garage at one time.
So that was part of the issue. The second floor is an apartment. It has its own access, its own designated area. But when the guy who built the house in the 1980s, he was a home builder. He only got it in the 80s. I don't know how they handled it, but it was only ever permitted as a garage, and a garage apartment is technically eligible to be considered an ADU under the zoning code, but it was only ever permitted as a detached garage. So we had to get retroactive approval for it to be converted to an actual ADU in order to get the short-term rental permit. That process I actually started about 2 years ago. I had to get multiple engineering letters, again, work with building services and kind of get that all taken care of. So it was ready to rock and roll as evidenced by the bookings, but we had to go through some administrative steps that I candidly just did not have time and needed. Daycare is expensive. So, but the second floor is completely isolated, no access. They don't have access to the first floor garages. Those are all fenced off and separated. Those are owner storage. We have a pool, so we have like a, kids' toys and stuff in there, but they don't have access to it. We've had no issues at all. Again, over 100 guests.
So your guests don't use the
No, they don't use the garage. They don't have access to it. Everything's fenced off completely. If you go to the picture of the site plan where the you can see down the driveway. One more. You drive down that driveway, and at the very end, that's where they park, and they can actually turn around. Yeah, right where Mr. Hare's label is. But they have their own entrance. It's all fenced. They can't access our backyard. We pass them in the street. We offer bikes, beach chairs. Yes, love it. We're a mile and a half from Shim Creek, 2 miles on a bike. It's pretty enjoyable location.
It's just one bedroom, correct?
It's just one bedroom, yes, sir. It's a pretty sizable living room, and we have a queen size pull out with a chair plus a kitchen table, all in like the living space. You can kind of see it. We have a lot of friends who do the short-term rentals, and living on the property, I used to live downtown, and my wife, to convince her to actually let me do this, was like, I don't want to be having a bunch of parties in our backyard. And so we intentionally only list it for 3 people to avoid multiple people. It's mostly couples that are coming in town for a wedding or are a single person coming for work or coming to visit for the weekend. Candidly, the people are very rarely there. I mean, they're out doing whatever you do in Charleston on a weekend when you're visiting. So we've had no issues. In fact, a lot of our neighbors, family members, I let them use it kind of in the off season when they're here for Thanksgiving if they need something. So it's pretty easy to maintain.
Are most of your bookings on the weekends or throughout the week?
50-50. I mean, it really does run from, most weekends are booked. Well, I'd say most during peak season, spring till fall. Winter is not a lot of activity. That's why I let my neighbor, who's a good friend of mine, his brother stays there when they come for Christmas. I don't charge him, but it's just friends and family using it when in their off season, which I don't think is a violation for the record.
Stop talking. He's eating that bait. Okay. Anyone else have a question? Thank you for the testimony.
Thank you.
There's nobody else in the room, so this is closed to the general public. Board members, gosh, my brain is fried. Any general discussion? Any questions of staff? Can I have a motion, please?
I'll make a motion to approve, Mr. Chairman.
Yes, please.
In case BZA 03-26-00966, this is an application for short-term rental, extended home rental. I make a motion to approve. The requirements are governed by Chapter 6, and in particular 6.82C 1 through 3. All conditions have been made. This is not going to adversely affect the general, the community. Adequate provision has been made for setbacks and buffering and such. There's been a thorough investigation, a well-presented case. Number 3, it complies with all applicable rules, regulations, laws, and such. In making this motion, I would incorporate into my motion the 4 conditions recommended by staff. That's my motion.
Thank you, sir. Do I have a second?
Second.
All right, Ms. Smith. All right, any discussion, questions? All those in favor, please indicate by saying aye and raise your right hand. Aye, it is unanimous. Congratulations, sir. Your application has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Once again, thank you so very much for coming and your patience. Good night, sir. Mr. Hare, you're leaving us. That's forbidden. I rule it. But we also have Mr. Carlisle.
Yes, sir.
Welcome aboard. You'll be taking reins of this when, Ms. Working?
Yes, he's been here since 2022? Yeah.
Okay.
So,
He hadn't been doing Mr. Harris' job, but
yeah.
Oh, wow. Okay.
He filled in for Josh, and then he filled in for Lee, and then
Oh,
We appreciate
well,
that.
I was unaware of that.
so he's tired of filling in, so he's just going to do it.
I've been rezoning planner working with planning commission council.
Thank you. Welcome aboard. Anything for our next meeting?
We just have 10. Another long meeting. Sorry.
Thank you for all. I do. Means adjourned.
You did a good job. You did a wonderful job as always. You are so good.